Chair, yeah, I'm still applying my mind on how to do this very. So when we had our discussion, I think we discussed our evidentiary assessment in detail when we did it on that day. And then our inputs were done. But this report was presented, but we didn't go into detail. It was just to capture what was submitted, and then we were coming here to discuss it. We have a superior content team. So what I would propose is that we move in onto what our recommendations and our findings are, and then it has to find expression in any other part of the document where it needs to be. However, we're going to have to do that secondary approach of verifying that whether there is actual enough evidence to back up what it is I'm saying. For example, if I say Honorable Kosana must go and to the ethics committee because he lied under oath. I'm giving you an example. We must be able to go and under Honorable Kosana's evidentiary assessment, etc., and be able to do that. Because what I'm concerned about, if we just rush and we get to our recommendations and findings, and then the rest does not find expression under all the other themes and headings, we're going to look extremely clumsy. So someone who reads this report without having the back knowledge, it's going to be like, but how did they come up with this? Because it's not sufficiently covered. So I think the content team can run with it and must be able to find and make sure that if we agree that this must be a recommendation or finding, that it's adequately covered in any themes or any headings above in the report. And I think that would be progressive. I just don't know how we're going to handle, Chair, when we disagree on what the inputs need to be. So maybe it should be noted, and then we spend another day where we deliberate on what our approach is going to be on matters where we're not going to agree on, and that it's noted. Otherwise, we're just going to go on for a long time going. So I think we must note objections. I think I've already noted an objection to Honorable Saul on what he was saying, but we can go back and forth. So maybe on the areas where we're not agreeing, it must be noted, and then we have we allocate time where we go back and forth and summarize and agree on how we're going to move. Thank you, Chair.
You listen, honorable members. You are not disagreeing between yourselves in terms of approach, because if you remember the initial proposal that Honorable Sangweni made was that let's take the report theme by theme. And in a theme where a member would want to make findings, you make those findings and suggest recommendations. So we will be done with that theme. And so now, because I can see that, and that is why I was very worried that you look very nervous and tense. It's like you are going to the examination room. And that was a sign to me that there is a difficulty in terms of how we're approaching the report. And that's why the second proposal then is to allow every member to say whatever they want to say on the report. And then if you want the content team to go back and say, we have factored all your inputs, your findings and recommendations. Let's say, for instance, on theme 1, these are the areas of agreement. And these are the areas of disagreement. Where there is agreement amongst committee members, it means it's a unanimous resolution. And then where there are areas of disagreement, that is where we will then develop an approach on how we discuss. And if we disagree, we can then agree to take an approach of majority and minority recommendations. So now, when I rotated with yourselves, I wanted to check whether you still want us to proceed with the approach of going theme by theme, or you desire the approach of allocating each one of us time to make their own observations, findings, and recommendations. And then we conclude the meeting. Honorable Souls, you were next.
Chair, I know that we are not deciding on which approach we're going to use now, but
Yeah.
I'm just thinking, let me say what I think. I lean more towards the theme by theme,
Yeah,
because when we deal with the findings and the recommendations, we are now making sure that it speaks to each other in the themes,
yeah,
and we get to the findings. And Chair, you will sympathize with me, because what this has done in the public court of opinion
yeah,
is we all as members has received certain labels by South Africans.
yeah,
For example, I have the label that I'm protecting the drug cartel.
yeah,
Now I'm sitting here, and to propose a balanced view, and I mention Minister Mkhunu, I will again be looked at as I'm protecting Minister Mkhunu and others. But I'd rather risk that and maintain the integrity of this committee that says we will present our findings in a fair and balanced way.
yeah,
What we found about General Mkhwanazi, the positives and the negatives. What we found about Minister Mkhunu, the positives and the negatives. We present without no emotions. So what I was raising earlier was just to say, what I've spotted is the things that Minister Mkhunu raised is not, there's not a balanced reflection. And so I will emphasize that. For example, another one, and I close with this, is there's no mentioning or even alluding to the fact that Minister Mkhunu is the one who canceled the Ketmatlala tender. So it should speak of executive intention that we are dealing with here. So we must zoom into what is our posture in the report. So I'll rather run the risk, but I will fight for a report that presents fairness and it preserves the integrity of this committee. Thank you, Chair.
Honorable James. Anything to say? Honorable Breitenbach.
Thank you, Chair. Yeah, you know, we can go around in circles all day. Certainly looks like we intend to do that, sadly. But we should bear in mind that all of us, all of the members of this committee are not finders of fact. We're not a court.
Yeah.
Weighing up evidence and making findings of fact is a very, very, very difficult and very, very, very specialized task that many experienced judicial officers struggle with. None of us have that experience. We are not finders of fact. Our job is to find weaknesses and problems present in the current system that governs the South African Police Service, the National Prosecuting Authority, and the wider criminal justice system, and to make recommendations on how we best think those can be resolved. We cannot find people guilty. We cannot find people innocent. We can find that people have misled us when the objective, glaring facts suggest that, and we can make recommendations in that regard. But we cannot find guilt and innocence. So we needn't waste our time with respect debating those issues. There's a very important paragraph in the report on page 427, paragraph 15.16.2, which says exactly that. The evidence before, and evidence is used in the widest possible sense here, because what we heard here was not evidence, it was information. It was not tested, it wasn't cross-examined. There's nothing to support it. There's no supporting evidence or extraneous evidence or real evidence to support most of the information that we heard here. So to call it evidence is a very generous term. But the paragraph says, where evidence before the committee reasonably suggests that a witness may have knowingly provided false or misleading evidence to Parliament, the National Assembly should consider referral of the matter to the appropriate authority for assessment. That's our job. We have no other job. And so we can go around for days complaining about what people said, but it's not really relevant to what our job is. Thank you, Chair.
Honorable Ngola. Covered. Chief Whip. Yeah.
Me, I'm getting to business.
Okay.
Yeah, I'm.
So honorable members, for progress sake, we are going to take this approach. We will take the report theme by theme, and then this is what we are going to do. If there are members who want to make complete submissions covering all areas, I'm also going to give them an opportunity so that they must not just be passive in the meeting, waiting for the afternoon. So can I check how many of us want to speak once and make their submissions? Is Honorable Skosana, Honorable Matthews, Honorable James. Yeah, so I'm going to take the Chief Whip now. And then when the Chief Whip is done, we will take Honorable James. Honorable Ngola. Want to speak? Did you understand what I'm saying? Yeah. Do you have inputs to make on theme 1? Oh, okay. Chief Whip, may you proceed?
No, thanks, Chair. Chair, I'm going to make a proposals, and I'm departing from the understanding that we all have read the report. We have our own views about what the report says in terms of the substance. And I want to start off by raising issues that, in my view, have not been properly canvassed in the report. The first one, and it's part of the recommendations that I'm going to be making, so that at some point when you decide that there must be a debate in the committee to determine whether the majority or all of us or some of us agree with this recommendation, you know that it's a specific recommendation. We leave it to your discretion to decide at what point will you want us to discuss and address areas of divergence on various recommendations. So the first one deals with the matter of the directive on the halting of the crime intelligence post. My own reading of the report is that there are no specific recommendations or findings on that matter. And I want to make the following submission. So that it's easier for the meeting chair, I'm going to read it on record. That a decision by an executive or administrative authority should rationally relate to the purpose for which a power was given. So a decision must also bear a rational connection to facts and the information available to the decision maker on which the decision is proposed to be based on. The SAPS Act and the regulations promulgated by the minister grant the National Commissioner authority to decide on the creation and filling of posts within SAPS. The minister, that is now the point I want to emphasize. that the minister, in my view, misconstrued his powers, as there was no empowering provision in law that gave him the authority to unilaterally decide that the post should not be filled. So that's the first point that I want to make with regard to the directive on how to handle the intelligence, the crime intelligence post. The second, that's
Finding.
my proposal that we should make as a
It's a finding.
finding
Yeah.
on the matter.
Yeah.
The second one I want to make, Chair, relates to the directive of the minister, because as you would notice, I'm dealing with the three aspects of the directive first and foremost, because that is what occasion our existence as this committee following the press conference by Lieutenant General Mkhwanazi. The second one has to do with the directive on ports, or the ports of entry, as were recorded on the intervention by the minister. Here, I'm also making an observation of something that has not been explicitly found in the report before us. And the point that I'm making there is as follows: that the minister was within his powers to issue a directive in terms of Section 207, subsection 2, directing that the National Commissioner develop a plan to assess the personnel impact and efficiency of police at the ports of entry. So that's the finding number 2 that I would like to put before the committee for consideration. The third one is on the disestablishment of the PKTT. Again, here I'm going to be making a point on a matter that does not appear on the report explicitly covered on the findings by our team on this report before us. And the point there is that there was no meaningful consultation between the minister, the president, and the IMC and other stakeholders. The assessment of work of the PKTT was not conducted, and the minister's reasons for disbanding is not entirely supported by what would have been a sequence of well-grounded facts before or at his disposal. So that is the third point that I want to make as an observation of the findings, having listened to everybody who appeared before us, including the minister, as well as you remember, the affidavit from the President of the Republic of South Africa. And then the fourth point I want to talk to, is it 4? Is 5. Point number 5.
Number 4.
Number 4. I'm not sure if I'm still within the same theme, but I want to take 4 or 5 points and stop, yeah, even if they are not in the same theme. This one deals with the allegations that the minister is a member of a criminal syndicate. Again, I want to make a point here, which I suggest should constitute one of our findings. That is not also coming up on the report. And the point is that the allegations cannot be, in my view, cannot be sustained and be supported by evidence before the committee. So with all that we've listened, I have a sense that the report recognizes the fact that we listened to this issue about criminal syndicates, but it doesn't spell out clearly whether we should be considering a finding which implicates the minister on this matter. And that is why I'm making the point that I've already explained. The last 2 points I want to make, Chairperson, is that the first of the last 2 deals with the existence of what is called the drug cartel, or the Big Five, as it has been commonly known. Again, the point there is that the evidence of its existence and the coordination, I think we need to make the point that is inconclusive in terms of what has appeared before us. We can't stand up and firmly say, we can say with certainty that does exist the big cartel or the the Big Five, as it has been argued before us. The last one, Chair, that I think I want to weigh in on is the alleged corrupt relationship between Minister Mkhunu, Mr. Mkhwanazi, as well as and between Mr. Mkhwanazi and Mr. Matlala. The point I want to make there is that in terms of what was at our disposal, evidence of corruption between Mkhwanazi, Mr. Brown Mkhwanazi, and Minister Mkhunu is, in my own view, still remain unproven as well as inconclusive. And it relies largely on what one can call speculation and a conjecture, not necessarily substantive evidence with which you can stand on to confirm that indeed the two gentlemen, Minister and Mr. Mkhwanazi, have entered into some corrupt relationship. And I want to conclude by saying, as well in terms of the evidence that can confirm that deals with corruption between Mr. Mkhwanazi and Mr. Matlala, and that corruption being done on behalf of Minister Mkhunu, I also hold the view that the report should indicate in our finding that we can't make a conclusion like that because the information before us does not confirm such. Of course, I want to qualify my statement there that it may, however, be necessary that further investigation is carried out to determine if any link of that kind exists between the minister and Mr. Brown Mkhwanazi. Now, I'm making that qualification cognizance of the fact that that investigation would not necessarily have to be done by the ad hoc committee. Once the ad hoc committee has concluded its work, it may have to decide which other agencies of the state would be appropriate to handle that matter so that they go deeper than what we were able to do as the ad hoc committee. So for now, I want to rest it at that point, Chair. I have other comments to make, but let me not monopolize the meeting.
In the next things. Chief Whip, because this was your slot to speak on theme one. If you still have anything on theme one, you can exhaust all your issues. You are fine on theme one. Yeah. So wait. The content team has captured what you have said for theme one. So now we are going to take Honorable James. Honorable James' inputs are across.
Yeah, just
Are cross-cutting.
few ones. Thank you, Chair. Chair,
Am I representing you correctly that you are speaking on all from theme 1 to theme 7?
yes, thank you, Chair. And a detailed report has been submitted for
Thank you,
incorporation.
thank
So I'm
you,
just going to
thank you.
highlight on a few
Thank
of
you so much.
our findings and the recommendations, if that's
Yeah.
okay.
You
Okay,
can go
so
ahead.
part A is part of our submission, strengthening evidentiary standards and accountability. Authentication of the evidence, the finding there, the committee received various forms of evidence, including video material relating to General Mkhwanazi without any accompanying evidentiary framework governing authentication, verification of chain of custody, right? This creates a risk that findings may be based on material whose reliability cannot be independently established. So we have that finding, and our recommendation is that the committee should formally adopt and record a clear evidentiary standard requiring that video, audio, and documentary evidence be authenticated before being relied upon in any finding. Authentication should include, where appropriate, forensic investigation, documented chain of custody records, corroborating witness state testimony, and/or other recognized methods of evidentiary verification. Where evidence cannot be satisfactorily authenticated, the committee's final report should expressly record this fact and refrain from drawing adverse findings based on such evidence. Then, on witnesses who misled the committee, our finding during the proceedings, concerns arose that one or more witnesses may have provided false or misleading testimony to the committee. Recommendation, the committee should resolve that any witness reasonably suspected of having knowingly misled the committee should be referred to the appropriate authorities for investigation, and where warranted, prosecution under the powers, privileges, and immunities of Parliament and Provincial Legislator Act 2004. Such referrals are necessary to uphold the integrity of parliamentary oversight processes and deter further misconduct. B, security vetting, access control, and senior appointments. Security clearance as a precondition for access. The finding, evidence before the committee highlighted significant weaknesses in SAPS' security vetting regime, including instances where members occupied sensitive positions or accessed classified information without valid security clearances. This extends to Mr. Nkabindi's appointment, his prior relationship with the minister through the IPID matter, the informality of the chief of staff role, the changed evidence, the preconceived inoccurrences, and COVID recording episode collectively point to a minister's office operating without the adequate institutional guardrails. The recommendation, SAPS policy regulations and when necessary, legislation should be amended to entrench a strict no clearance, no access principle, whereby no member may access classified information systems or facilities without an appropriate and valid security clearance. Security clearances must be periodically renewed and reviewed, and access privileges must automatically lapse upon the expiry, suspension, or downgrading of a member's security clearance. The appointment of chief of staffs and senior officials in ministerial offices within the security cluster be subject to security vetting at a top secret level as a precondition, not merely as a parallel process. Number two, parliamentary confirmation of senior SAPS appointments. Our finding, allegations of political interference in SAPS appointments underscore the need for greater transparency and independent scrutiny. Recommendation, the South African SAPS Police Service, the South African Police Service Act 1995 should be amended to require parliamentary confirmation hearings for appointments to the following positions: National Commissioner, Deputy National Commissioners, Provincial Commissioners, and the Head of Crime Intelligence. Such confirmation processes should include public hearings and parliamentary approval before appointments are finalized. Part C, depoliticizing SAPS and clarifying operational independence. Clarifying the relationship between the minister and the national commissioner. Finding, evidence and expert submissions before the committee highlighted ongoing uncertainty regarding the constitutional relationship between the Minister of Police and the National Commissioner. While Section 207 of the Constitution provides that the National Commissioner manages and controls the police service in accordance with the national policing policy and the ministerial direction, legislation does not adequately define the scope or the limits of such ministerial authority. This creates a significant risk, like we've seen, of political interference in operational policing. Recommendation, Parliament should initiate a comprehensive review of the SAPS Act to provide legislative content to Section 207, Section 2 of the Constitution, a legislative definition distinguishing policy directive, in brackets, lawful ministerial function from operational directives, functions exclusive to the National Commissioner. All ministerial directions to the National Commissioner must be issued in writing and accompanied by reasons. Such directions must be preceded by consultation with the National Commissioner. All directions must be tabled before Parliament for oversight purpose, and legislation should identify a minimum category of operational matters in respect of which ministerial direction is prohibited. These prohibited areas should include decisions relating to individual investigations, decisions relating to specific criminal cases, operational deployments, appointments, promotions, transfers, and removal of individual officers, and decisions concerning specialized investigative units, including units analogues to the former political killings task team. Can I continue, Chair?
Yes.
Almost done. Part D, strengthening oversight of crime intelligence. Parliamentary oversight of crime intelligence findings. Evidence before the committee identified weaknesses in parliamentary oversight of SAPS crime intelligence operations and expenditure, including oversight of Secret Service accounts. The recommendation: the oversight mandate of the Joint Standing Committee on Intelligence or other suitably mandated parliamentary structure should be strengthened to include regular substantive reporting obligations, enhanced access to operational and financial information, powers to comply testimony and documentation, and appropriate safeguards to protect legitimate national security interests. Extending the Auditor General's mandate, the finding there, current limitations on the Auditor General's powers create an accountability gap regarding the auditing of certain SAPS secret and intelligence-related expenditure. Recommendation: Parliament should pursue legislative amendments extending the Auditor General's mandate to include SAPS Secret Service and crime intelligence accounts, subject to appropriate confidentiality and national security protections. This reform would significantly strengthen financial accountability within SAPS and is very important. Operational and administrative reform, digitization of case docket management finding. The continued reliance on manual docket management systems create opportunities for tampering, loss, delay, unlawful interference like we've seen, thereby undermining criminal prosecutions and public confidence in the justice system. Recommendations: SAPS should accelerate the implementation of a fully digitized case docket management system, incorporating secure electronic records, role-based access controls, comprehensive logging of all docket activity, enhanced evidence preservation mechanisms. Such reforms would improve case management, reduce opportunities for corruption, and strengthen prosecution outcomes. Almost done. Review of SAPS organizational structure. Findings: evidence before the committee suggested that SAPS maintains a management structure that is disappropriately top-heavy relative to its operational and investigative capacity. The recommendation: an independent organizational review should be commissioned to assess SAPS's rank and management structure with a view to reducing the unnecessary management layers, improving organizational efficiency, reallocating resources towards frontline policing, and strengthening investigative capacity. State-owned devices for official business. Findings: the use of personal device for official SAPS communications and operational matters impedes oversight, weakens evidentiary integrity, and undermines institutional accountability. The recommendation: all SAPS officials, particularly those in senior management, intelligence, and oversight sensitive roles, should be issued with state-owned phones, laptops, and other official device work for related work purposes. Such devices should remain the property of the state, be used exclusively for official business, and be subject to lawful access, audit, and oversight processes in relation to SAPS-related conduct. So Chair, this is just some of our findings with the recommendations. Like I mentioned earlier on, a comprehensive report has been submitted for inclusion, for consideration.
Thank you so much, Honorable James. So that completes our, no, we still had Honorable Sangoni on theme 1. No, she has spoken to all the things. You want to do it like her. No, she said that she only wants to make those cross-cutting findings and recommendations. Honorable Ngola.
Chair, it looks like it's so difficult for you today to notice me or recognize me.
No, I have recognized you.
Should I proceed?
I even wrote your name down.
Should I proceed, Chair? I thought you.
It's your time to speak now.
No, thanks very much, Chair.
The last will be Honorable Sangoni, and we move to theme 2.
Thanks, Chair. I also wish to adopt the process done by Honorable James. Just try to speak on everything. I think the first thing, Chair, which stands out, particularly on theme 1, is the issue which the Chief Whip has touched on also, which relates to executive authority, which I think some of the members would have misunderstood the issue. And executive authority, Chair, isn't derived from evidence tabled in the meeting. It is specifically derived from legislative and policy frameworks. So I also agree, Chair, with the Chief Whip when he speaks about what the minister would have misconstrued as his powers and what was within his power to attend to anything. Let me not expand, Chair. The Chief Whip has covered on that part. I want also, Chair, to cover to just one aspect in relation to theme 6, the interagency coordination. I think, Chair, it is common cause that there is a need for law enforcement agencies to coordinate their efforts to eliminate duplications where necessary. So I think let's specifically give that obligation to the JCPS cluster to develop an organized crime and corruption strategy, which will align the investigations as it relates to organized crime. As we speak, Chair, for example, we have an issue of Mr. Matlala, whose case is in IDEC today. Tomorrow is in the PKTT. The other day is in crime intelligence. The other day is at IDEC. So we do need that coordinated strategy that must be developed by the JCPS cluster to coordinate matters in a proper and efficient way so that we don't have duplications and infighting about things that really do not matter. Chair, I think we have part of what we have noted as this committee during the testimonies is that we can all agree that IP has been compromised. Compromised daily and being made an ammunition by some people in the security cluster against some people in the security cluster. So I think, Chair, we should stress it that IP should recruit and train investigators independently from SAPS, TPCI, and IDEC. So we should give powers to IP to recruit its own staff. You'll recall the issues of someone being moved from crime intelligence to IDEC, from IDEC to IPID, from IPID to this and that. So we need an expedited legislative amendment that gives IPID to do its own recruitment on issues of staff. An issue, Chair, which is raised in theme 5, which is organized crime, infiltration, and institutional resilience. Here we want to recommend, Chair, that the Minister of Justice and Constitutional Development, the Minister of Police, must also develop a framework that guides the movement of personnel in between the different enforcement organs of the state. Just what I've just said, the SAPS, TPCI, IPID, IDEC, you'll find that there is a lot of duplication in terms of recruitment of a personnel. If you'll recall, we once had a discussion about some fellow Mr. Johnson who was moved from crime intelligence to IDEC with some recruitment process being in question also. So I think there must be a standardized framework developed between the Department of Justice and the Ministry of Justice and the Minister of Police on how the personnel is moved amongst these organs. Chair, we mainly have dealt, fortunately, Chair, I also speak on this matter as the chairperson of the Portfolio Committee on Justice. We mainly have dealt with the powers of IDEC. The powers of IDEC in the main are derived from executing the recommendations and findings of the Party Commission, of the Nugen Commission, of the Zondo Commission. But the NPA Act actually allows them to deal with any matter of serious corruption matter that they deem it fit to deal with. And Section 27 of the NPA Act actually accords them powers to act on referrals where a certain Mr. Ngola suspect that a certain Mr. Skosana has been involved in a serious corruption matter, and I go and make an affidavit. But we think in the main, Chair, the threshold to those referrals is just too low, in that it just requires me to present my face and do an affidavit, then it ends there. Then IDEC investigates. So our thinking, Chair, around this aspect is that the Portfolio Committee on Justice should look at amending the NPA Act, in particular, Section 27 that gives powers to IDEC to act on referrals. Was the allegation at the face of our people is that IDEC, through that Section 27, is now being weaponized as an agency that fights individual battles instead of fighting corruption, the same issue that it has been established to do. You know what's worse, Chair, is that with the 3 commissions, from the official establishment of the changing of IDEC from ID to IDEC in 2024, they have only finalized 9 matters out of hundreds. Because they are small resource, they even directed to some other things that they've got nothing to do with the findings of these 3 commissions. So we move, Chair, here by recommending to the House that let Section 27 of the NPA Act that deals with IDEC referrals be dealt with. Chair, I think let's say it here in this meeting that what Mr. Adams alleges to be a receipt of an intelligence information from a particular door doesn't really make any sense. And we think that how even it was adduced arrogantly in this committee feeds to the same narrative that Mr. Adam would have been used also to enter the battle that has nothing to do with him and his parliamentary obligations. But I was saying, Chair, was what is our worry mostly here is that there is intelligence information that is going around exchanging hands. If an intelligence information can be found under a door of a person, it means there is intelligence information that is going around changing hands, which is very dangerous for the sustainability of the security of the country. So we want to recommend, Chair, here that the crime intelligence must actually investigate this matter further. And also want to give an obligation to the, I'm so hurt, oh yes, Mr. Cameron is here. Want to also say, Chair, as coining this recommendation, the portfolio committee on police must have regular oversight follow-ups on this matter. Because our belief, Chair, is that the work of the ad hoc committee in relation to the matter at hand ends, but the work of Parliament in relation to the matter doesn't end. So the portfolio committee of both police and justice must also follow up on the matter. Chair, there is also a very uncertain issue relating to the evidence of Ms. Mkhwebane, which in our view that from being a member of the Joint Standing Committee on Intelligence and for being a member of Parliament in general, having taken an oath, at least she should have better understood on how to handle some of the information that comes to her disposal. Most particularly the issues relating to intelligence information, whether classified or not classified, what kind of classification is it? Our understanding is that Ms. Mkhwebane was in a better position, having served in the Joint Standing Committee on Intelligence. I'm being sabotaged now. Chair, that
Your battery went flat.
I think so, Chair, but I'll stop on this part, then I can come back later. Then I can come back later.
On
maybe.
which theme?
So I'm saying
On which theme were you?
we're on the last one. But so we were saying here, Chair, in respect to the conduct of Honorable Mkhwebane should further be referred to the Ethics Committee to further run an investigation on and make a determination of what Parliament needs to do in respect of that. And Chair, we're doing this in our understanding, not only for this ad hoc committee, but even for ad hoc committees to come.
So what did you recommend on the assessment of Honorable Adams?
We recommended, Chair, that let the crime intelligence investigate further on what would have happened in respect of the document that was said to be an intelligence document, and the portfolio committee on police must regularly follow up on
what is the reason for exempting him from the Ethics Committee of Parliament?
We can also, Chair, add and say we can add him that the Ethics Committee of Parliament must also
because
follow up on.
If you recommend one and you leave the other, all of them are members of Parliament, and the Ethics Committee regulates the conduct of. I mean, if that recommendation is accepted, just for completeness sake.
Thank you, Chair. Yes, we fully agree. And Chair, we also want to recommend that also Ms. Mashale must be investigated for her conduct in disseminating the intelligence information. You'll recall, Chair, that she also said that she exchanged information with Mr. Adams, and some of which was even posted on some portions of it was even posted on social media platforms. Chair, I think we part of what becomes our observation is that we've got a serious vetting problem within crime intelligence. Because you find that crime intelligence vets itself. It's more like we come, we vet ourselves. So it becomes easy for those who want to deal with a certain Mr. Nduli to deal with him in respect of the vetting outcomes. So we recommend, Chair, that crime intelligence must have an agency for vetting, both crime intelligence and SSA. There must be an establishment of an agency that deals with vetting. You'll recall, Chair, that here we even got allegations of people having been employed within crime intelligence whilst having criminal records. So there are a lot of things that are said. So to curtail that, we recommend that there must be an agency established to deal with such kind of vetting. I think, Chair, the issue of the spending, I think Honorable James touched on issues relating to the Auditor General and all that. I think we also, Chair, would wish that let there be an audit on the spending of crime intelligence. You'll recall, Chair, that we have had numerous testimonies that alleging that there's a misuse of the secret fund account within crime intelligence. The bills have been escalating. We even went to an extent of calling the CFO.
You want to introduce auditing or accountability mechanism?
Accountability
Okay.
mechanisms, Chair. Let me try to move fast, Chair. The issue, Chair, of employment conditions within crime intelligence is also becoming some kind of a loophole that may have driven some of those within the employ of crime intelligence to be found less accountable, solely because they are not part of what they call the employment, the basic conditions of employment act, the Labor Relations Act, blah, blah, blah. So we propose, Chair, that even in crime intelligence, the personnel, the human resource of crime intelligence and SSA and defense intelligence must also be subjected to the Conditions of Employment Act and the Labor Relations Act. So there's an issue about the missed document, which doesn't really give authority to anyone where an intelligence information gets stored. Who is the custodian of the intelligence information? So it becomes a bit tricky because it gives whoever has it as a custodian. If it's in Parliament, then the Parliament presiding officers are custodians and all that. So we call upon the ministers responsible for this kind of information to rework the misstep. Back then it used to be State Security Minister. It looks like we no longer have now, it resides within the office of the president, but the executive authority responsible for this kind to rework and amend the MIS document to explicitly give an authority to a particular agency on the custodianship of intelligence information, so that there is proper accountability. If there is a leak, if the intelligence information is exchanging hands unlawfully, there must be someone who is responsible for that. There's an issue, Chair, of the state, the information, what is that? Protection of Information Bill, which I think also needs to be expedited. So we are saying the recommendation, Parliament must expedite that, the processing of that bill. It's already within Parliament. Chair, I think, Chair, for now, let me pause there. Thank you very much.
Okay. On the custodianship of classified information, what do you say on the nature of information that may be classified? Can I classify a corrupt information?
No, Chair, that's one of the reasons we want an authority to know what it's. If there was some part of what becomes our observation is that it's to a certain level or to a certain extent, we tend to hide crime through classification. We use classification to hide crime. So that's why we say there must be an authority. Of course, Chair,
that's why because it's in two parts. The first part is on, which you spoke to, is on classification.
Yes.
Which you recommend that there should be one central agency. Because now, as it stands, the author of the document is the one who has the power to classify or declassify.
Yes.
And then secondly, you are also adding to that recommendation that maybe even the nature of information that is to be classified, you need to categorize what kind of information can be classified and what kind of information may not be classified. If I want to protect myself from my corrupt activities and I'm the author of the document, or I have power over the document being authored, I can say it must be classified.
Yes.
And it gets classified. Okay. Are you done?
Yes, Chair, for now.
Yeah? No, it's not for now. You're not going to abuse my members in the meeting.
Yes, Chair, I'm done.
Okay. Honorable Bradenbach, do you want to say something? Oh, okay. Welcome, Honorable Cameron and Honorable Mwango. Can you just make sure that they have the relevant documents, Honorable Mwango and Honorable Cameron? Okay, Honorable Sangoni, you were the last on theme one.
Thank you very much, Chairperson. The truly superior content of Honorable Nduli and Honorable Ngola has covered me. I just want to make just one addition, I think, to the issues that Honorable Ngola was dealing with around the IGI. And we are obviously concerned about the conduct of the IGI when he had been requested by the minister to profile Ms. Mashel And we think that there should be an investigation by the relevant intelligence authorities into that. And then on the matter of the Border Management Agency that Honorable Ntuli had raised, we also wanted to propose, in line with the report, a referral to the portfolio committees on Home Affairs and Police, but also the vetting of personnel at the BMA. I think at the center of the dispute that arose between General Musigiri, I think, and the minister was the implementation and interpretation of a section of the BMA, which specifically says that, and I just want to refer to it now, Section 4.2 of the BMA Act, which provides that border law enforcement functions within the border law enforcement area and at ports of entry must be performed exclusively by officers of the authority. So we support the referral of that to the portfolio committees on police and home affairs, but that the SAPS must also ensure that all members who are deployed to these ports are vetted as a matter of agency, and lifestyle audits where necessary should be conducted. Thank you, Chair.
Thank you so much. And I'm going to request to members that where we propose that matters or recommend that matters must be referred to respective law enforcement agencies. We may also need to come with time frames on the regularity of reporting before Parliament, so that you don't have an ad hoc committee this year and 15 years later, the recommendations remain unimplemented. It's something that Van Zyl House, we may have to look into on the time frames on our recommendations, so that we become action orientated. Can we move to theme 2? Yeah, we're moving to, are we done? Theme 2, honorable members, is on operational effectiveness, task team governance, and case management. There are some of the recommendations that have been made by Honorable James and Honorable Ngola, which pertain to this theme that we are dealing with. Can I check those who want to speak to theme 2? If your hand is not noted on theme 2, for now it's only one hand. Yeah.
So for now, Chair, we are taking themes, not the.
No. I said I'm going to exercise the degree of flexibility.
Okay.
I know that you yourself and Honorable Matthys, you want to make cross-cutting submissions.
Yes.
But if you checked, I took Honorable James and I took
Yes.
Honorable Ngola. They are done. So they're not going to speak for the whole duration of these deliberations, because they have now been given a chance to make their own submissions.
And as well, are we allowed to send it to the Secretariat? Because if I have to do the whole thing, Chair, it's going to take long.
Yeah, what I'm doing, I'm exercising a degree of flexibility.
Okay.
So if we give you a chance, like if you saw what she did.
Yes.
She said, I'm not going to read everything because I've already made a submission, but I have points that I want to emphasize in this meeting. You see, it's particularly on the findings and the recommendations. So at the time we note you, we may want to check. In fact, the most efficient way will be to check with you how much time you may need so that we don't allocate your time and you speak for the next 2 hours. Yeah. Okay. Honorable Souls on theme 2. Are you ready? Yeah.
All right, thank you, Chair. I think maybe maybe I should start with what Honorable Ngwala has recommended and just make a remark on that. The issue of us recommending that Honorable Adams must go to the Ethics Committee. And also that Ms. Mashale, we must recommend that she should be investigated. I want to state for the record that it is those two people, amongst others, that brought a balanced view to this committee with issues that could be substantiated. We cannot stop any investigation, criminal investigation or whatever, against Honorable Adams outside of this committee. But for this committee now to, by implication, treat him as someone whom we have concluded has done something wrong or hasn't assisted the committee, I disagree with that.
Order, Chair.
Okay.
Sorry, Honorable Souls.
No, before you speak. Honorable Cameron and Honorable Mwango. Theme 2 is from page 278 to 298 of the draft preliminary report. Okay, Honorable Matthias, can we hear the point of order?
Chair, we've just resolved that we are going to give our inputs on findings, recommendations, and on the themes. And we'll note where we don't agree, and then we will set time aside to have discussions and deliberate on the points where we do not agree, Honorable Souls. So I think we must move in that direction, otherwise we're going to go back and forth. And it was something that we had agreed to as a committee, Chair, that we deal with the points of contestation amongst us at a different time. And right now we are just providing our inputs on what we can capture. Thank you, Chair.
Point sustained.
Chair, I am making a remark for noting, not discussing. Honorable Ngwala has made his input. I'm stating mine for noting. We're not discussing. Later on, we can deal with the merits. But I have to state that we must not treat it as though there was no contribution made. When we look at what was presented, he was correct when he said the docket was locked up in an office. That was a true and tested testimony. Now to treat it as if it's unethical and so on, it's something up for debate. But I must make a remark, similar to Ms. Mashale, who was a whistleblower. She brought her evidence here. Now we want to treat it as if it was criminal in a sense. So I'm making a remark, and I have a right to do so.
Point of order.
I'm making a remark. We can discuss it
Can I rise
later,
on a point of order?
but I'm merely making a remark.
Okay, let's hold it there. Honorable Souls, here I see there are two hands, Honorable Ngwala and Honorable Skosan.
Chair, it is basically deliberately misleading to say what we have submitted suggests that we have found people guilty. And our argument, Chair, was that let there be an extensive investigation on the matters. And the matters we have raised, Chair, are undisputed matters. It's not disputed, Chair, that Honorable Adams found a paper or an envelope under the door. He said it himself. It's not disputed, Chair, that Honorable Kola Barnard acted on a particular information, went to the public, went to the minister and all that. She said it herself. It's not disputed, Chair, that Marshall posted things on Facebook. They were flighted here in this room. She said it here. So if we recommend a further investigation, we don't say anyone is guilty. We don't say anyone we have got overwhelming evidence against. Hence, we're saying an extensive investigation must be conducted. So I agree with Honorable Matheus. We're going to have a problem, Chair, here if people do not make their submissions, and then we come down and say, on point A and B, this is where we disagree. Then we'll have an issue, because the more we want to entertain other people's submissions instead of advancing our own submission, is going to cause us to go back and forth. So from where I'm seated, Chair, Honorable Saul's out of order on two aspects. One, misquoting what we have submitted. Two, continuing with what we have said is going to have to be given time to be dealt with. Thank you.
Honorable Skosana.
I think Honorable Ngola said mouthful, because I just wanted to say that otherwise we're not going to go anywhere. I'm going to make a submission, somebody's going to raise his hand, and you know, we'll go, we won't fit in the chair. And I think Honorable Ngola has summed it up. Thank you, Chair.
Honorable Sauls, the point of order is sustained.
Chair, is that not considered input on the matter? Are you saying that the point of order is that I must raise what I'm raising in a later part of the meeting? Or are you saying it must not be raised?
No, the point of order is that you do not respond to what other members have said. Make your own submissions.
Yes, that's part of my submissions, but I'm saying, are you saying that I should raise what I'm raising, not now, later? I just want to understand the point of order.
No, we are now on theme 2.
Yes, I'm going to address.
So any matter that is falling between pages 278 and 298, make those submissions.
Yes. I will do so. I must understand, will I be able to raise what I'm raising later, is what I'm asking.
Even now, if you want to raise any matter that falls within the theme, raise.
Our format is that we've agreed on themes.
Yeah.
Honorable Nwala has done the whole thing, his whole thing.
Yeah.
So in other words, myself and Honorable Sangoni, for example, is doing theme by theme. So if I need to understand, because he raised everything.
That's what we said.
Should I wait till later to deal with that elements, or should I totally leave it?
You know, when I checked with members who want to do cross-cutting presentations or submissions, it was very few. You were not one of those who wanted to make cross-cutting submissions. And that's why we said we will exercise a degree of flexibility. We will take those who want to take the report theme by theme. And if there are those who also want to speak at once, we will accommodate. You can indicate to me and say, no, I want to speak now and on everything. I don't have a problem. No. I will allow you.
No, Chair, I'm okay with theme by theme, but you must guide me in terms of if I hear something, like from those who doesn't present theme by theme.
Yeah.
Do I wait until later
Yes.
All right. So I
Yes.
can address what I'm addressing later. All right.
Yeah, so you have decided to take the report theme by theme.
Yes.
Yeah, so we are now on 278 to 298.
Yes. So
Yeah.
I will deal
And
now.
don't be intimidated. Just get to your
Advisor needs, I'm
yeah,
never.
Muni Bison.
Advisor no.
Yeah.
So on page 284, 13.4.9. A, cost, sustainability, and the institutionalization. Lieutenant General Dempani's evidence provided an important and substantially documented financial perspective. The expenditure recorded against the PKTT project code amounted to approximately 434 million from inception to 30 September. The principal cost drivers were overtime and travel subsistence, including accommodation, meals, etc. The amount was substantial in absolute terms, but was incurred over then 6 years. The comparison with selected SAPS intervention did not show, this is where I want to zoom into, Chair. The comparison with the selected SAPS interventions did not show the PKTT to be an obvious expenditure outlier. Now, the evidence that Lieutenant General Dempani produced showed the opposite of that statement. It actually showed that the PKTT was an expenditure outlier. So that should be reconsidered. On page 18 of what she presented to us, table B, she gave to us to show that the expenditure over the years, when you exclude the CARA funding, which she testified is not part of the SAPS funding or budget, it's separate. So you can't include that when you measure whether or not PKTT was a financial outlier or not. So when you exclude CARA, which was 1.1 billion, and you exclude the 2021 unrests, which in the financial year 2025, 2026 was zero, so you can't consider that either in determining whether PKTT was an expenditure outlier. So when removing those two and then comparing the PKTT with Thunder in Cape Town, with the March shutdown and the Amanguzi cross-border KZN, it then becomes clear that PKTT in comparison was the expenditure outlier. It's there, but the report says something else. So I make that submission, Chairperson, that it is not correct for the report to say that the testimony of Lieutenant General Dempani was saying that the PKTT was not the expenditure outlier. Most of the budget over 5 years was spent on the PKTT. That's the fact. Then I would like to see an addition also, because again, I'm dealing with having a balanced approach of testimonies, not so that the report must not lean more to one side, even though we are not finding anybody guilty, but it seems like we are not presenting a balanced view of the facts. So what section 13 does is it isolates the accounting officer's compliance concerns, which is General Dempani, about the PFMA irregularities from the field operational continuity. By treating these as competing personal testimonies rather than systematic failure of task team governance, the report fails to explain why the unit was allowed to operate in an administrative vacuum, because that's what we need to zoom into. It's not who's right or wrong, it's about the systematic breakdown administratively in our SAPS. Then, of course, the operational stagnation section, the section also focuses strongly on the word immediately, without evaluating how a sudden unconsulted directive paralysis or operational effectiveness on the ground, how that was impacted, creating confusion between provincial commands and national directives. So, although the friction caused by the directive is stated, but it fails to critique the severe threat that abrupt, immediate de-establishment poses to case management, specifically regarding the whole active documents, evidence preservation, and witness protection. So for it to reflect some balance, we propose the following. Operational handover protocols and case management standards. This edition must evaluate properly the phrase immediately against standard police administrative law. It should state that an immediate freeze on a specialized unit operationally threatens active criminal investigations. To preserve case management integrity, any directive to disband must structurally mandate a phased, secure handover phase to prevent the compromise of active dockets. And we've seen that in the testimony that happened afterwards, but it should be something that becomes standard. So, as a finding, the committee should find that a profound vulnerability in task team governance has occurred while operational commanders acted in substantive good faith based on strategic continuity authorized by the IMC resolution on 5th September 2023. This decision was never translated into a formalized SAPS administrative mandate. This omission left the unit technically non-compliant under the PFMA, creating a structural governance gap. Another finding proposed from our side, the operational effectiveness and case management, the committee finds that issuing a directive for immediate disbandment without prior operational consultation or a predefined transition period severely compromised operational effectiveness. It created acute risks to case management by threatening the continuity of active dockets, confusing the chain of command between national and provincial levels, and stalling active investigations. Recommendations. We propose the following recommendations in this regard. It is recommended that the National Commissioner implement a mandatory standard operating procedure for specialized units within 45 days. This blueprint must require that any task team established via strategic political directives must possess an internal SAPS charter co-signed by the accounting officer, defining its explicit lifespan, budget lines, and compliance milestones. Last recommendation, for case management preservation, it is recommended that a strict case management preservation protocol be introduced. No executive or administrative directive to dissolve an active investigative unit may take effect instantly. A mandatory 30-day operational winding down phase must be legally enforced to audit, secure, and digitally log the transfer of all active dockets to regional or local command structures. That's it for theme 2, Chairperson. Thank you.
Brilliant. Thank you so much. Can I check if we still have more speakers on theme 2? Going, gone. Is 2. Is Honorable Matthys and Honorable Sangun who are breaking for lunch now. And then we will come back at 2:10. May you still?
We're taking theme lunch break.
No, we're now breaking. When we come back, it's only 2 last speakers on theme 2.
It's
Yeah.
theme lunch break.
You are ordered to stand up and leave. It's only 2 speakers here. And you? Okay. You are ordered to stand up and leave. proceed with the meeting, can I check those members that I have recognized to speak on theme 2? I don't see anyone.
We
of them.
consider the matter finalized, Chair. Thank you.
We consider the matter closed. We now move to theme 3. Can I note hands of members who want to speak on theme 3? Theme 3, we are on page 298. The theme is crime intelligence, instability, and intelligence-led policing. Honorable Thopper.
Thank you, Chair. I'm going to go through everything I want to say. Is that fine?
Hello?
Can I go through everything with the flexibility arrangement?
Yeah.
Chair,
How much time do you need?
I won't be long, Chair.
Okay, yeah.
I won't be.
Yeah.
Yeah. Chairperson, on page 376, 14.2.8, it speaks to, I just need to get there, sorry, with the device, the IDAC and the MPA structures and so forth. And it speaks also on 392, 14.15.4. So I bring those two together, and as well as the recommendation of 5.2, that the wording of the MPA, including IDAC under MPA, should say truly independent, free from executive overreach, and as well as financial independence. I'm not of the option that the MPA is currently independent, as what the report would suggest. There is a recommendation that they have independence, but I think that they should have their own budget. They should be financially independent, Chairperson. So that speaks to recommendation 15.2 as well. Chairperson, then I will move to page 382. Chairperson, I don't agree with this paragraph at all in the sentiments that it gives. And it says that, and I'm not arguing that there is enough evidence to say that the guilt can be placed at the feet of either the minister or the SAPS leadership. But the buck needs to stop at the actors that are at the top of their respective spheres, whether it be executive or operational. And that this responsibility then needs to be shared, but the buck does stop by them. And to say that it is just, how can you say, overall accountability of governance, it's almost like a cop-out. And I think, Chairperson, that we must really word this, that the people who are responsible for their specific tasks need to shoulder that responsibility. Otherwise, we can, every time something goes wrong, just call it a governance accountability issue or a trouble, without those who are actually in charge and receive the salary to actually take accountability for their actions. Chairperson, that would be 14.7. And then in 14.5.8, it speaks of the IGI. And I think that is also very important because the IGI report never saw the daylight in this committee. And I think it's being used as a smokescreen. And I think that the recommendations need to really speak to where IGI or where secrecy ends and accountability starts. Chairperson, we can move to page 384. Chairperson, this one speaks about the record keeping, and it speaks to, and I think it speaks to specific officials that are responsible. Again, it's in a recommendation, it's very loose to say, what should be done. But we also have to say, who was in charge of these dockets that were moved? What is the accountability there? And it is a major problem. And I don't think we can just leave it as a matter of future fixing. but it has to be fixed what has happened and somebody has to take responsibility. And this matter should be then investigated further and find out who was ultimately responsible. And the consequences need to follow. There needs to be consequence management for this type of failure.
Which number is that one?
Sorry, Chairperson, that would be 14.7.3. And that would go with recommendation 15.5 of the dockets.
Okay. It's page 384.
Yes, Chair.
Okay.
Sorry, I just now need to find my page again. On 14.75, Chairperson, it lists risks, and it says that the risks are loss of institutional memory, delay, evidentiary compromise, duplication, so forth. But it seems that it misses the most important risk, and that's of the South Africans. If there's cases that are damage to this exact loss of dockets, and that we might be speaking about high-profile cases here. But if we are going to name the risks that losing and moving dockets causes, then South Africans' dockets that are lost should come first on that list. Chairperson, so the recommendation is that it must, in those risks, include the damage that it causes to South African citizens as a major risk concern. Chairperson, I'm just keeping it short because of time. I really don't have too many. I just want to check quickly. I covered 592. Chairperson, page 592. There's a weakness between SAPS, crime intelligence, DPCI, IDAC, IPID, NPA. And Chairperson, in this committee, we heard that there is communication and they understand it. We've done oversights at IDAC just recently. And when questioned on communication between SAPS, IDAC, NPA, etc., it was said that there isn't a problem. And then in recent interviews that we've seen on TV and on social media, you again see that there's some issues and communication challenges between high-ranking officials in the SAPS and high-ranking officials in IDAC. So there's obviously an issue within this communication, and I think in the recommendation there needs to really be a structure of communication between SAPS, IDAC, NPA, DPCI, and so forth.
Is it communication or competition between?
I would say communication because the questions were all on communication. And it was indicated by Advocate Johnson that there is no communication problems, and it's a media thing that's created the impression that they don't have synergy and proper communication. However, just in recent statements again made televised, there was a communication problem between high-ranking officials and IDAC. So I think that this recommendation needs to be boldly stated, Chairperson. Chairperson, I won't repeat the point, but again, 5.29 is the wording of the NPA must have true independence of financial independence. It must include financial independence, Chairperson. Chairperson, I will end there. Thank you very much.
Okay. Thank you so much. Can I check? Do we still have members who want to speak? Yeah. No. We have now just concluded theme 3 because yes, we are done with theme 3. Can I check if there is any who wants to speak on theme 3? Yeah. Honorable Matthys.
Thank you, Chair. Chair, theme 2, theme 3, all the themes we have inputs as the EFF. So I don't know if you would, I wouldn't mind us just going through and presenting what it is that we have as the EFF across, including our recommendations and findings, and then we just close and, or you want me to only deal with the
How
two?
much time do you need to go through all of them?
Maybe about 4 hours. I'm joking. I don't think it'll be more than 15 minutes. Yeah.
Okay,
So on,
so you go through all the things,
yeah,
okay.
and I can go under page by page. So on point by point. So on theme 2, 13.4. 13.4, and then we go under F. Our input here, I'm just going to read so it goes quicker rather than me talk to it. As you know, that I can overtalk sometimes. The evidence establishes that the political killings task team was an effective and productive investigative structure and it achieved significant operational success in the investigation of political killings, organized criminal violence, and related offenses. That's our input over there. And then we move to I wish I had just extracted our inputs rather than having to scroll through the entire report. Under 13.4.14, and then after section F, we would just like more clarity on the National Commission, and we think it should be captured like this, that the evidence establishes that Lieutenant General Sabia played a significant role in decisions relating to the transfer of the 121 dockets, the future of the PKTT, and the broader operational matters examined by the committee. That just doesn't come out very clearly in that regard. And then under theme 3, 13.5.2, and then just under B, our input there is that the evidence demonstrates that crime intelligence experienced prolonged leadership uncertainty, extensive vacancies, contested appointments, governance disputes, and operational instability during the period under review. And then we go further under F. This needs to be clarified. The committee finds that the moratorium, yeah, that's the word, imposed on the appointments within crime intelligence materially affected the ability of the division to perform its functions and contributed to operational weakness identified by the witnesses. It just needs to come out much more clearer than what it is captured at the moment. Then we are under, I'm skipping through a lot of pages. Just bear with me, Chair. It's only because we've captured our inputs on the actual report, so I have to see where we at. Then we move under 13.6.3. The relationship between Minister Mkhunu and with Mr. Mkhwanazi. And then under G, our submission here is that the committee finds that the accumulative effect of the evidence creates a reasonable basis for concern regarding whether public institutions and decision-making processes may have been vulnerable to improper external influences. The committee further finds that the evidence presented regarding the interactions between Mr. Mkhwanazi, public officials, and other individuals connected to matters before the committee warrants further investigation by the relevant law enforcement and anti-corruption authorities. The committee finds that the evidence concerning the relationship between Minister Mkhunu and Mr. Mkhwanazi was characterized by material inconsistencies that were not satisfactorily resolved during our inquiry. And the evidence demonstrates that the differing explanations provided regarding the nature of the relationship, the frequency of the interaction, and the extent of the communication between the parties The committee also finds that aspects of the evidence presented on the issue were contradicted by documentary material, communications record, and other evidence placed before the committee. And the committee further finds that these contradictions raise legitimate concerns regarding the accuracy and the completeness of certain explanations provided during the inquiry. The committee finds that the evidentiary record establishes sufficient grounds for a comprehensive ethics and integrity investigation into the relationships, communications, and interactions between public officials and private individuals implicated in matters before the committee. And then also on to 13.6.14, and then under subsection D, the committee finds that the evidence concerning Mr. Brown Mkhwanazi is one of the most significant and reoccurring features in the inquiry. This evidence demonstrates that Mr. Mkhwanazi's name appears repeatedly across multiple and otherwise unrelated evidentiary strands examined by the committee. And the committee finds that the evidence relating to Mr. Mkhwanazi emerged in relation to communications provided by senior public officials, matters concerning the PKTT, issues related to Mkhwanazi, interactions involving the Ministry of Police, and broader allegations. The committee further finds that the reoccurring appearance of Mr. Mkhwanazi across multiple evidentiary stands cannot reasonably be regarded as incidental. The evidence establishes that Mr. Mkhwanazi occupied a position of unusual proximity to individuals exercising public power despite not holding a formal position within SAPS, the Ministry of Police, or any other relevant law enforcement structures. The committee finds that the evidence raises serious concerns regarding the extent of Mr. Mkhwanazi's access to information, decision makers, and matters falling within operational responsibilities of state institutions. The committee further finds that the explanations provided regarding the nature, the extent, and the purpose of Mr. Mkhwanazi's involvement were not always consistent, and it did not satisfactorily address concerns raising from the evidentiary record. The committee finds that the evidence demonstrates the existence of communication and interaction that warrants further investigation by competent authorities. The committee further finds that the evidence establishes prima facie basis for investigating whether improper influence was exercised over public officials, law enforcement institutions, or operational policing matters. Then we move on to 3.7.7. Under D, however, the committee finds that the evidentiary record discloses sufficient grounds to justify further investigation into the nature of Mr. Mkhwanazi's relationship, activities, and interactions. I just read that, didn't I? No, Chief Whip. This thing is just jumping all over. But we're on our final stretch, though. You learned from me, Chief. Chair, most of this is covered. Then on 13.10.2, under public participation evidence, our input there under B is the findings and recommendations that follow should therefore be understood as oversight findings grounded in evidentiary record and directed at fulfilling the mandate conferred by the committee by the National Assembly. At least I'm not giving the whole background that Honorable someone did. On 14.2.15, the committee further notes that the findings of irrationality, procedural irregularity, maladministration, poor governance, oversight failures, misconduct, or institutional weakness do not amount to findings of criminal guilt. Such findings fall squarely within Parliament's constitutional oversight responsibilities and are necessary to inform appropriate recommendations. In undertaking this responsibility, it is necessary to distinguish between findings of fact falling within the committee's oversight mandate and the determinations of criminal or civic liability, which properly falls within the jurisdiction of courts and other competent authorities. So that falls under that section. And then under 14.5.5, the committee finds that the evidence presented during the inquiry discloses serious governance failures, institutional weaknesses, and accountability deficiencies across several components of the criminal justice system. The committee further finds that these failures created conditions in which disputes concerning authority, operational control, intelligence, utilization, specialized investigation, and institutional accountability were able to develop and persist. And on 14, I think you want me to have a break because I'm even tired of reading. 14.6.5. This is on the PKTT. The committee further finds that the circumstances surrounding the directive of the 31st of December 2024 and subsequent transfer of investigations and operational consequences arising therefrom reveal serious governance failures, deficiencies in accountability, and weakness in the institutional safeguards intended to protect specialized investigations. I'm going to leave it there, Chair, for now. What other input I wanted to make, and it can't, I don't know where we're going to make this fine expression here, but I don't think it's an exercise that we've done. As the committee, we were faced with this challenge of we've had witnesses come before us and they give us a sworn affidavit and they give us testimony and they can tell us two different things about exactly the same event, which means that they have no problem going to write a sworn affidavit or coming before Parliament and misleading Parliament. And unfortunately, we do not have the power to say this one purged themselves or didn't do that. But we need a process where we go through and we identify the cases where we've had conflicting testimony. And in our recommendations or in our findings, number one, we must identify that. And in our recommendations, it must be that Parliament must open perjury charges against those individuals. And obviously, they would need to go and answer, and the court of law will decide whether they purge themselves. I mean, some of the matters are not necessarily strongly related, Chair, to what we were investigating, but we need to give a very strong message that we must take sworn affidavits in this country very seriously. It cannot be that senior officials in our criminal justice system can just write a sworn affidavit, come and sit here and mislead us, and we don't do anything about it. One such example is not necessarily, well, one of them is the Robert McBride and the issue of him having or not having a sexual encounters or relationship with a Sarah Jane Train. So that matter must come to the floor because he came here under testimony. He said he didn't. She came here and she said she did. Clearly. So that must be one of the matters that must go, and we must open a case of perjury against them and let the court decide who purged themselves while they were before us. Thank you, Chair.
Thank you so much. So, Honorable Matheus, are you done with your submissions? Did you want to speak, Honorable Sokanyila?
Yes, Chairperson.
What do you want to say?
Can I talk?
Yeah, I want you to tell me first, do you want to make cross-cutting submissions or you only speak on theme 3?
No, I will talk to cross-cutting issues. that have been raised by honorable members, some of them.
Okay. Yeah, you are allowed.
Thank you, Chairperson. Chair, looking at the issues that have been raised by honorable members, referring to referrals and consequences, there are some that have been left out. For instance, even in the report, the committee has noted the allegation concerning the acquisition, access, use, or dissemination of personal financial credit related and other protected personal information without making any findings, Chairperson, regarding the legality of such conduct, whereby the committee maybe will recommend that the National Credit Regulator, the Information Regulator, and other competent authority assess whether any matters disclosed during the inquiry warrant further investigation in terms of the National Credit Act of 2005, protection of personal information. Then it won't have recommendation, but where we need to take those issues, the relevant law enforcement agencies must investigate for possible violation of National Credit Act, conducting lifestyle and assessing the credit information of individuals without the necessary authority. This is informed the fact that you have Sarah Jane Trent, who in her statement, she confirmed that she became a fraud examiner in 2019. But looking at the evidence that she presented before the committee, she actually started before that, because she started in 2016. In what she presented here, she was already conducting the credit checks and running a lifestyle audit. And yet, she's not mandated a chairperson to do that.
So your observation is that at the time she was practicing in that responsibility, she did not have the certificate.
She didn't
Okay.
in 2016.
You can,
And we're leaving that hanging as the committee.
yeah.
We're not referring it to the relevant law enforcement agencies.
So your suggestion is that it must
It
be
must be,
included in the assessment and findings and recommendations.
surely.
What is the recommendation?
I'm saying that it must be investigated, taken to the relevant law enforcement. I'm going further.
Yes, it's your time.
Oh, okay. With regard to Paul O'Sullivan, must be investigated for violation of National Credit Act, for assessing credit information without necessary authority. Has referred that. Then if we're going to look at the investigation into fraud and theft by South African police and other statutory enforcement agencies, conduct such an investigation, O'Sullivan and Associate is not a law enforcement agency, but he did behave as if he was one. We cannot leave Paul O'Sullivan. And we have noted that the NPA has been reluctant to re-enroll the matter against Paul O'Sullivan and Ms. Sarah Jane Trent regarding the allegations of impersonation of IP investigation. If you remember, the Lieutenant General Pahlane issue going there, disguising as IP'd investigators and intimidating General Pahlane, that warrants an investigation by the law enforcement for statutory crime of intimidation and common law of offense of attempted extortion. Because if we are looking at what Lieutenant General Pahlane placed on record, he placed on record emails before the committee that was sent by Mr. Paul O'Sullivan to him, which stated that in January 2016, where he was pressuring to pursue criminal charges against certain police officials, he was purportedly investigating. And when he refused, it started to intimidate him, and he started to threaten him. And he said that if you are refusing in my demands, I will turn my attention to you. Then on February 5, 2016, he said, if you don't take action against Muno, now I'm turning attention in you. So he was threatening Pahlane on that. And he also, on the 12th February 2016, gave ultimatum with threat, fix Muno now, or you'll go the way as slavery. We cannot just leave it as the committee, the issue of slavery, to threaten someone with what happened to another person. It's serious. So we cannot just leave that. The NPA should enroll the issues against Paul O'Sullivan. And then again, Mr. Sullivan be investigated. That one is not included. Be investigated for violation of Section 3 of the Protection of Information Act. Mr. Paul O'Sullivan, in many threat to General Pahlane on the 5th February, he said, I should mention that, he said to him, I should mention that I have now formally notified the British and US Secret Services that the leadership of SAPS is knowingly supporting Al-Qaeda by protecting known Al-Qaeda money laundering cells of South Africa. You know, those issues that were raised by O'Sullivan, and also in his own admission, under questioning, he testified that he worked for the British government. So we cannot just see Kenji talking also about the terrorism placing South Africa and other things that we don't know. We cannot just leave it. And then another thing, Chairperson, the delegated role of deputy ministers. I think I should talk to that, whereby the presidency should develop a framework regulating the delegation of responsibilities to deputy ministers and associated parliamentary accountability arrangement in order to strengthen transparency and responsible and oversight. The president must develop a framework that guides the assigning of delegated responsibilities to deputy ministers by ministers. You know, when the presentation was done here, some of the committee members, they wanted to say that we don't need any deputy minister. We need those deputy ministers, but there must be a delegated framework that must be done by the presidency. And with delegated functions to be shared with Parliament for its oversight function in accordance with Section 93(2) of the Constitution. And then again, in institutional culture, discipline, and ethics, the government should assess whether additional safeguards are required concerning the movement of former members of specialized intelligence, covert, technical, and high-risk operational environment to private security industry, where such movement may create security intelligence or conflict of interest risk. This is according to the evidence that was given by former Minister Bheki Cele. The state spends about 1.1 million to train one member of police special force. We lose these members to the taxi industry. That's what he said. And the private security industry. If we're going to look at Mr. Matlala's security, he said there are former police special force members who are working for him and they're earning big monies there. And they do the job. If we just leave them as they are, amendments, I'm saying that the amendments to the SAPS Act and its regulation is proposed to impose restriction on special force from joining the private security sector. The minister may promulgate regulations that will empower the National Commissioner to issue clearance certificate granting permission to a member who wishes to render a security service or similar approach adopted for crime intelligence members or intelligence service regulation may be consulted for a similar approach. Let me pause there. I'll come again. Thank you.
May you stay as an honorable member. May you stay true to your commitments. Because you said it here in front of television when you started that you are making cross-cutting recommendations. And yeah, drink water and finish your recommendations. I can give you between 30 seconds and 1 minute to help.
Thank you very much, Chairperson, for giving me that time. And then, Chair, also on the institutional culture, discipline and ethics, the Portfolio Committee on Police, Honorable Cameron, should further consider a comprehensive review of rank structure, organizational culture, and institutional ethos of SAPS to assess their alignment, with the constitutional principle of democratic, accountable, and service-oriented policing. Such review should consider the implication of existing organizational arrangement for leadership, accountability, public trust, community-centered policing, and professionalization, and whether any legislative, policy, or administrative reforms are required to strengthen a policing culture grounded in constitutional values, responsiveness, transparency, and respect for human rights. Hence, we're saying that in the final analysis, the extent of corruption, abuse of power, lack of accountability, and disregard for the law by senior members of the SAPS is a matter of grave concern. This cannot be viewed in isolation from the militarization of the police service. To this end, the Portfolio Committee on Police should consider a review of the militarization of police ranks with an intention of reorientating the police as a service, not as a force, Chair, in accordance with the values enshrined in the Constitution. At least we must remove some certain powers of that militarization to the police. Demilitarization should therefore include returning the ministry and the department to the language and ethos of the Constitution names as a service orientated to the safety and security of the people, and retiring the force culture that militarized the ranks entrenched. We recommend the report should flag the nomenclature and ethos. Then, the matters that may disclose criminal conduct, corruption, procurement that were raised there, where appropriate matters involving potential criminal conduct should be referred to the NPA, including the Investigating Directorate Against Corruption and to the Directorate for Priority Crime Investigation for further assessment and investigation. Because if you look at retired Lieutenant General Vuma, came through the public participation process. She was here carrying documents, Lieutenant General Vuma, through the public participation process, and further alleged that former Minister Cele interfered in the operation of SAPS by influencing and directing which companies should get PPE tenders from SAPS. She further alleges that Minister Cele was central to the irregular runaway cost associated with transaction of acquiring the Telkom Tower building, which had ballooned almost 2 billion from 605 million. This matter warrants further investigation and recommends that DPCI investigate the involvement of the former minister and other actors that they can get to, that were involved in that. Additionally, Lieutenant Juma alleged that during March 2020, Lieutenant General Peter Jacob, who was at the time a Divisional Commissioner of Crime Intelligence, and Mr. Cele purchased interception equipment to the value of 120 million rand without prerequisite exemption certificate from the Department of Justice and State Security. As a result of this, the interception equipment that they purchased remained utilized and wasted for years. This may have been a scheme unutilized. This may have been a scheme to loot the Secret Service Fund, as there was no intention to utilize this equipment. Therefore, we recommend that this must be investigated. To the people whom I've said it referred to them, they said it must be done. Then again, another issue that came out from public participation, Mr. Mesuli Mlando alleged that Lieutenant General Spear, while serving in the city of Johannesburg, as head of internal anti-corruption unit, irregularly procured spyware equipment to the value of approximately 18 million, while the municipality lacked authority to possess such intelligence equipment under constitutional and statutory frameworks. Then we recommend that the allegation made by Mr. Mlandu against Lieutenant General Spear be investigated further by other law agencies and to determine the veracity of these allegations and determine the existence of this spyware equipment. Chair, I'm coming up with those recommendations. That must be included. I hope this committee will look at those issues. Thank you.
I listened to you very carefully. On the reorientation of the police system in this country, whether you want it to be a police force or whether you want to render police services. Yes. And the observations that you would have made on the witnesses, some of them who appeared before us, Mr. McBride and Ms. Sarah Jane Trent, Mr. Apollo Sullivan, and lastly, with that official from Joburg Metro, Mr. Mlandu. Now, I heard all those things. And even our superior content team, Ms. Van Zyl-Hoos, and Ms. Silkstone and Dr. Dr. Kok. They had all those observations and recommendations that you are making and the proposed referrals. So that's brilliant. Thank you so much. But most importantly is that you have exhausted your right to speak in this meeting. That you must be reminded. You must stay true to your commitments. It's not me. It was you who said, allow me to make those cross-cutting recommendations. And I have allowed you. Honorable Skosan, you have not spoken today. And you have been very, very patient. I must give you credit for that. Yeah.
Thank you, Chair.
What do you want to do? You want to go theme by theme or you want to?
No, I'm going across.
Okay.
Yeah.
You want to exhaust your rights?
Yeah, I just want you to be patient though, because I know it's going to be a very, very difficult one. But obviously you gave everyone a chance. So I was listening, I never interrupted anyone, and hopefully no one is going to interrupt me. Yeah. Thank you, Chair. As I was saying, I'm going to not only going on theme, I just want to make sure that I cover everything here, especially I'm alone today. The MK party submits this comprehensive review of the Ad Hoc Committee draft preliminary report, 23 June 2026. To ensure that the factual accuracy and transparency is in line with the committee mandates. This submission draws on the latest evidence on Hansard witness statement to correct any misstatement or omissions to align the draft report with the verified record. Our aim is to strengthen the report's integrity by incorporating the MKP input consistently with prior submission and the public deliberation while avoiding substantive policy debate on those input themselves. I think you remember, Chair, that I think it is us, the EFF and the ANC, who have put inputs, after we received that draft report. And I guess that would be as well be incorporated, into the final report. First, we presented a refinement matrix summarizing how the MKP proposal related to each section of the draft. We then offer a chapter by chapter critique, highlighting factual corrections, proposed wording changes, and underlying rationale. All changes suggest are substantiated by official sources, and we note where the draft already accords with evidence. Citations from the committee owns record and related documentation are provided. This submission is laid out as a committee document with cross-reference to the evidence. It is intended to supplement, not supplant, the draft report, and all final decision remains with the committee. Summary of the key input from us as refinement metrics. Section 7, limitations. Added the limitation noting that no oral evidence was given by the president, although he provided written response to the committee. Questions and note that Major General Feroz Khan, Crime Intelligence, was not called to testify. Record that certain plain witnesses, e.g., Khan, remain outstanding, and that some evidence, e.g., promised annexure to Advocate Johnson statement is still missing. And I think the committee will recall that. Advocate Johnson promised us that within two weeks, he will submit a response on what Honorable Nomvalo in particular asked. But that was not done up to date. Now, that issue which we started earlier this morning talking about, the PGM, if I remember, they've got records. The Hansard's got record of what transpired here. And I'm not going to withdraw anything. I'm still saying that I've said that many times, 3 times, the issue of Khan that he must appear here. And as I said, I even call him. Section 7, again, number 5, note that the unresolved allegations regarding Katiso Molefe and Morgan Maumela and General Mkhwanazi identify Mr. Molefe and Ms. Maumela as members of the criminal syndicate, but their roles remain untested. The report should record this as unexplored allegation, as the evidence leaders did. Now, the public participation, no specific input from us and from other parties beyond the standard process, but note that the public submission raised many of issues listed above. The section should summarize the input, witness protection, and documented access general consistent with the existing text. And I think we transverse the issue of Mashale and for better word, Professor Dihas. I'm not sure, but yeah. If you remember, Chair, that this so-called social media tweets, because Mashale was lying on that, he was testing the minister, Mkhunu, and, same as O'Sullivan bragging that he will bring every, in fact, as a matter of fact, it's him who said that, that he brought down then Commissioner Silebi. And the only thing which also even to me, which he accepted from this committee is one, that he was a rapist, because he pleaded guilty on that matter, in Randbeck. He accepted on that. He pleaded guilty on that. But on the other issues, there were a lot of speculation from him. Section 12 on evidentiary overview. Update to reflect an outstanding documentary evidence. The committee noted that during Advocate Andre Johnson's testimony that he had not received all the relevant documents and requested them urgently. Similarity, it was publicly noted that Advocate Johnson had submitted documents without their attachments, which members called unacceptable. The draft should record these gaps in the record. Section 12 of this evidentiary overview ensure that all public hearing testimonies are accurately summarized. In particular, the report must correctly portray Minister Mkhwebane's testimony. The evidence leaders found his testimony raised significant credibility concern, including the admission that he instructed the covert recording of General Mkhwanazi and that he misrepresented to Parliament the extent of his consultation with President on December 2024 directive. If the draft minimizes these points, it should be amended to reflect them. Section 12 of evidentiary overview. The draft should clearly state that General Khan was never called as a witness, despite numerous reference in evidence to his role. His absence was noted by evidence leaders as unresolved issue. The omission should be marked as a limitation, as MK Party proposed in most of the meetings which we had as a core committee. The findings and recommendations. I think we, as MKP, we note that the evidence leaders drew particular conclusion, for example, that the minister's directive on the 31st December 2024 was issued without consultation with the National Commissioner or the President. And with after the fact explanation that conflicted with the minister's own testimony, the draft finding section should accurately reflect these conclusions. Likewise, the recommendations about vetting, strengthening the task team, clarifying the crime intelligence mandates, and introducing the oversight, judiciary or legislative, are well-founded in the evidence and should be retained, expanded as needed. Scope and our term of reference. No specific MKP inputs were submitted on the basic introductory section in terms of reference. The draft background and the mandate statement appear sound, e.g., the establishing the inquiry under Rule 169, Section 1, following the Mkhwanazi 6 July 2025 media briefing. We note that the evidence summarized, they inserted later, you see below, clarify that the President affidavit explained it could not establish PKTT directly. As you know, that it was the issue of the IMC, that, other ministers were not informed about the disbandment of this PKTT. And I guess that Minister Mkhunu, except that he made a big mistake on that. The draft structure should ensure the consistency with the evidence leaders. Executive summary, e.g., President role structures of the PKTT without a factual error. For instance, any text suggestion that the President himself created a task team must be corrected to reflect that it was done by the Interministerial Committee on his behalf. Section 7. These are the limitations of the report before us. Written answers versus oral evidence. The MKP proposed that the evidence supports a limitation that no oral evidence was heard from the President, though he answered the question in writing. The draft already notes that the President did not testify, but should explicitly that written responses were received. The President press release of the 17 March 2026 confirms President Cyril Ramaphosa has formally provided the written response to the committee in question. And I think when General Mkhwanazi was here, we transversed that as well to say the President has responded, though it did not appear before us. And that alone suggests that in some, in a public space, that the President is above the law, because he's the only person, who we called, who responded in writing. Besides that, the IGI, let us down in terms of one of the former member who was denied right to appear before us. This material context, readers should correctly infer that the President declined to engage. We suggest wording like, it is noted that President Ramaphosa have declined to engage directly, did not appear in person before the committee, but furnished us with a formal written answers to his question on the 17th of March 2026. The committee has acknowledged this response in summary. The lack of oral testimony is a limitation. We must agree, all of us. Though the president's written evidence is on record. The witness gap, the draft must be recorded that Major General Feroz Khan, Crime Intelligence Deputy, was never called to give evidence. Despite the centrality on his allegation action in testimony, the evidence leaders explicitly noted an issue repeatedly raised by Lieutenant General Mkhwanazi, namely the role of General Khan had not been fully explored because General Khan had not been called to testify. This language should be quoted or paraphrased as an express of caveat. Similarity in any other plain witness, e.g., Ms. Konda Barnard, or in-camera witness who possess classified evidence should be mentioned under limitation if they were not heard. As a member of this committee, I urge that this omission be documented rather than tossed over. And I think Honorable Ngola spoke about the issue of Honorable Barnard. To say, as she served in the, I think the Intelligence Core Committee, the Portfolio Committee there, that herself and Honorable Adams aired by publicizing these matters of crime intelligence in public. Mulife and Mawela allegation. General Mkhwanazi named Katiso Mulife, as I said earlier, as a high level and Morgan Maumela of syndicate members, so-called cartel. The draft limitation findings should say the alleged involvement of Ms. Mulife or of Mr. Mulife and Maumela was not tested in evidence. The evidence leaders report shows that Mkhwanazi names do not appear, but there's no confirming testimony. For example, Advocate Aren's summary notes Mkhwanazi identified Ms. Maumela on the 18th March 2026. However, without any cross-examination or supplementary evidence, this remains an allegation only. As you know, there's nothing which happened to Morgan Maumela as we speak. The only thing we know in this committee is that his vehicles were confiscated and nothing else. The witness allegation about a person such as Katiso Mulife and Morgan Maumela are recorded in evidence, but remain unverified and thus appear as untested assertions and in the report. This matches the MKP submitted amendment to the record as untested allegation with referral considered only if new evidence emerges. Scope beyond SAPS, the MKP point out that the inquiry span all criminal justice institutions, not just the police. The evidence supports this broad view. Numerous witnesses described as cartel influencing the National Prosecuting Authority, IDEC, magistracy, and correctional services. And I want to emphasize this, Chair, to you again, that I think I've raised this thing many times, that we have scratched the surface. You know, we have not eaten the meat. You know, we are still on the bones. The issue of the correctional service, in fact, was untouched in this committee. The issue of the judiciary was untouched in this committee. The only things which we hear in this committee in the last 8 months or 9 months was more about the police. And I think our chair who's sitting here, who I'm a member of the Police Portfolio Committee, can attest to that. And really, it's disappointing that we had a joint committee of the Portfolio Committee of Justice and Police. But when it comes to the issue of the judiciary, it's like the untested water. You know, I've raised that as well. And I'm saying it again, that when it comes to bite us as a core committee, you know, or maybe not in this administration, this should be noted that we've raised these issues. And I know that we will be tired, you know, of coming to this core committee, you know, as Parliament, there's a lot of work to be done in Parliament. But I would suggest, Chair, as well, to the Justice Portfolio Committee who's here, and the Chief Whip of the largest party is here, and the Chairperson of the Police is here. It's only the Correctional Service Chairperson who's not here. That we need to have another committee, maybe in the next 8 months, maybe next year by April. Because for me, we should not be feared of any government institution, be judges, be correctional service or whatever. We should make sure that we dig deep, into those institutions. Because General Mkhwanazi said many things. And I can tell you today, I'm told that Brigadier Macheni was dismissed. He's from the forensic unit in the police service. That tells you that this commission, whether Madlanga, which I had my doubt, when it started because of what happened to Zondo Commission. But there's results which are visible as we speak. Not only narrative or political statement or PR statement to say, some commission have worked. There's Nugent Commission, there's Mupati Commission. And, for me, I still have my doubt. Because for me, they were not biting. It's more about the big names. We've got this commission. They've got findings. And, when you have some chair, you have some, you seek for a legal opinion, but you still go against the legal opinion you seek for. The draft, this evidence chair supports this broader view. Numerous witnesses describe cartel influence in the National Prosecuting Authority, as I said. Now, that has to be probed, Chair. For example, the evidence leaders flag allegations of criminality infiltration within correctional service and the judiciary. Hence, I'm saying we have to explore fully these issues which were raised. We recommend that including language such as witness alleged cartel infiltration into a wide range of institutions like SAPS, NPA, IDEC, courts and prison, etc. But the committee inquiries into this allegation were necessarily limited to the evidence presented to us. In particular, one acting judge was mentioned in evidence, but no further judicial officials were examined. These remain an open issues. Public witness and confidentialization. We need to make sure that this should be noted. This should be noted. That the proposal about in-camera evidence, e.g., to protect whistleblowers, ongoing cases, the draft, current text on public participation should simply reflect what was done. Several members of the public, including the crime intelligence officers and civil society witnesses, did testify before us. Some under restricted conditions. Hence, I said about the IGI. One witness came in here, but unfortunately, he was not given a right to give us evidence here. And the chair ultimately scheduled closed session on sensitive topics. We have no specific factual correction here, but suggests a clarifying statement. Where witness or evidence requires confidentiality, the committee arranged closed session hearing or redacted transcript as agreed during the deliberation. See committee meeting minutes on the 11th of November 2025. This follows from the committee resolution to hold a closed session at Patoi's hearing. Section 10, public participation. No MKP, let me put it this way. No MKP specific submission beyond routine oversight. The draft already details the public submission process. We know that some submission, e.g. by civil society or police interest group, overlapped with the parliamentary evidence. The draft fairly summarized key components, community concern. MKP has no correction here. Section 12, evidentiary overview. This section must accurately summarize the evidence. Several MKP concerns arise regarding the presentation on the testimony and documents. Advocate Johnson evidence, the draft outlines Advocate Andy Johnson testimony on SAPS corruption and IDEC operations. It should include that the committee requests additional documentation at her hearing, which we asked her up to date. We have not received any. And I think that's undermining our core committee. As a parliamentary press release noted, the committee further noted that it had not received all relevant documents related to these investigations and requests that the outstanding information be submitted as soon as possible. The draft should say so. Similarity, the country shows frustration over missing attachment. One member exclaimed last week we had Advocate Johnson, she left some documents, no attachment. It is unacceptable. This contemptuous remark by our member, honorable member of the EFF, underlines the fact that important supporting documents have not been filed. We recommended and adding a brief note. The committee observed that some exhibits promised by Advocate Johnson and added by another witness were incomplete, e.g. Johnson filing select annexures, which was a matter of concern. Advocate Patoy evidence. Advocate Shamila Patoy, I know is retired. She not necessarily retired. I think her term of office expired. Advocate Shamila Patoy testimony covered prosecutorial challenges. The draft should appropriately frame her remarks. For instance, as Mkhwanazi party is of our opinion that is against that she concealed the name of a corrupt prosecutor. Patoy repeatedly explained that she referred the allegation to IDEC and will seek legal advice before disclosing any name. She alleged that her refusal was not for personal protection, but for due process. As she later explained, the draft should present in the context. Having refused to reveal the name of an alleged corrupt prosecutor, Patoy explained her referral of suspicious prosecutor to IDEC. And while pressured to name the individual was resisted, she cited constitutional protection for suspect. She offered to reconsider in a closed session, underscoring the legal caution. The committee minutes show she said she will consult the council before naming the person. Advocate Patoy on 19.3. It is the view that, that the draft preliminary report materially underrates the significance of Advocate Shamila Patoy evidence and fails to reflect the manner in which it was experienced by members during the inquiry. In the MK party assessment, Advocate Patoy deliberately concealed the identity of a prosecutor alleged to have been compromised by organized crime elements, notwithstanding repeated direct questions from committee members and despite committee oversight mandate. Her continued refusal to disclose identity, even after extensive questioning, it had a practical effect of withholding the information that was central to the committee investigation. The MK party further considered Advocate Patoy to have been among the obstructive, confrontational, and uncooperative witness to appear before this committee like Sullivan. With her approach, frustrating rather than assisting Parliament constitutional oversight function, I think that it's a cause for concern and that should be documented in our report. The draft report should therefore accurately record both the substance of the evidence and the significant concern expressed by members regarding a refusal to disclose material information, rather than characterize her conduct merely as an exercise of legal coaching or procedural restraint. The draft report should therefore state Advocate Shamila Patoy acknowledged that the information had to come to her attention concerning a prosecutor alleged to have been compromised by organized criminal element. It's viewed that MK party that notwithstanding requests by members of the committee, Advocate Patoy concealed the identity of that prosecutor. I'm emphasizing that. The MK party further considered that Advocate Patoy approach through her testimony was among the most obstructive. And I'll go to 19.4. Ms. Haas and Mkhwanazi allegation. The testimony of Ms. Mary Haas. I've changed now from Professor Haas to Mary. You remember when we started on our deliberation, when she came in as a witness, he came in as a professor and later a doctor, and now Ms. Mary Haas and Dr. Shamil Mkhwebane introduced an allegation against the now judged Haas, not necessary, Ms. Haas and Mkhwebane. The draft should accurately note what was heard from Advocate Patoy testified that her decision on the directive was influenced by unverified allegations from these sources. Despite the IG and the commissioner findings them unreliable. If the draft omits this, it should state that Patoi and Minister Mkhunu were informed about the IG and NC consider those allegations unliable. Lot rate evidence, if included. If the draft touches the testimony of Metro Police and the police itself, etc., nothing specific from us, I can that attest to you if that is included in the draft. But Minister Mkhunu evidence, the evidence leaders found Mr. Mkhunu testimony problematic. The draft must not whitewash this. We highlight 2 points. Recording of Mkhwanazi, as I said earlier, before you gave me this time, Chair. Mkhunu admitted ordering his chief of staff to secretly record General Mkhwanazi's testimony. And I said earlier that it was wrong. And I must repeat, it was a judgment of error from Minister Mkhunu. Advocate Arenze explicitly noted this admission. In the draft if the draft downplays this, it should be corrected. Minister acknowledged he had instructed a covert recording of the witness. That's a fact. A fact highlighted by evidence leaders as well. Consultation with the president. Mkhunu told Parliament that he had consulted the president about the directive, but Arenze records that he later misrepresented to Parliament what the consultation entailed. The draft should say that at least one of the Mkhunu statements in Parliament was contradicting by the documentary evidence. It should not be just vague. Overall, the evidence leaders concluded that Minister Mkhunu evidence raised significant concern, e.g. about the timing of the directive. You know, at the end of the year, whilst we're busy with Umpemba buying some, firecrackers, buying meat, all over, there was a letter which was as well linked by Brian Mkhwebane. Mkhwebane had that letter before our chairperson of the police had it here, or even the president. Didn't know that, and the chief whip here, he can attest to that. He didn't know about that letter. Now, the draft summary of Mkhunu, if any, should reflect this judgment. Perhaps quoting or paraphrasing Arenze language about the credibility issues. The core of this evidence concerning the PKTT directive, the draft correctly notes that Mkhunu issued the directive on the 31st of December 2024 to disband the PKTT. MKP urges it to explicitly state that the procedural irregularities, the directive was issued later on the New Year's Eve, was not brought to the National Commissioner, who learned over it via WhatsApp. And guess what? Mkhwebane had that. Brian Mkhwebane already had that letter. He was privileged. And for anyone to dispute the relationship between Brian Mkhwebane and Minister Mkhunu is misleading us. And I think it should be captured. And if he stated the reason, e.g. winding down the task team, came only afterwards and were not contemporaneous. These points are central findings from the evidence. We note that the evidence leader's summary and likely the draft concluded that whether this directive was lawful remains for the committee to decide. Any mention of possible justification in the draft should be balanced by noting that the leader's finding that was issued without prior consultation and that this may have exceeded the minister's power. And now we are saying it did, because we had the National Commission sitting here and we read the Constitution. Yeah, we know the powers of the minister. In terms of operational issues, it's a no-go area. It's not for us as politicians or the executive to get involved. Hence, like the committee, we only do oversight. Section 1314 findings of the facts and the conclusion, Chair. The MK party emphasized that the finding section must be tied closely to the evidence. The evidence leaders detail finding point 1, Roman figure into 4. It should guide the draft conclusions in particular. Directive ultravirus. The draft should highlight the anonymity of witnesses and the evidence leaders, that President Ramaphosa did not approve or even see the directive beforehand. And on his response, the president said so. If the draft proposed any finding that the directive was within the minister's right, that must be carefully qualified. The constitutional division of power suggests a minister cannot unilaterally suspend any active SAPS task team, which is operational. Or unilaterally, constitutional division of power suggests minister cannot unilaterally suspend any sub-task team which is an operational function under the commission co-control. The committee must decide that the point, but that draft cannot report the evidence. For example, General Masemola testified it was beyond the normal ministerial authority and was done without a customary consultation. We advised here that the language such as all witnesses agree that the directive was issued without the president or the commissioner's consent, whether it was lawful in context of section 206, 207 of the Constitution, is a matter of final resolution. Findings on the corrupt networks. We know that as an MK party that the evidence of systemic corruption, e.g. SAPS procurement, fraud, irregular investigation is substantial. For instance, the evidence leaders recount that Ms. Castle Matale, the Deputy Minister of Police, admitted that 500,000 cash payment to a former police minister during a tender irregularities. This finding justify the recommendations on reform, but also specific prosecution. If the draft findings, in fact, I'm saying Pegitele. If the draft findings list does not mention this admission, it should at least allude to them as evidence of high level complicity, and that should not be allowed. We should not be complicity in this committee. We should make sure that we are above board, because these millions of South Africans are waiting for this ad hoc committee. It cannot be a wasteful expenditure. Recommendation of recommendations, that section 14, Chair. The MK party supports the evidence leaders' forward-looking recommendations. In particular, we endorse the vetting reform, lifestyle audits, screening for senior SAPS posts, strengthening and continuing the PKTT, because the PKTT, undisputable. You know, we cannot equate it to a budget. When some political statements are made to say it was a waste of money, we know now 7 people have been killed as we speak here. Politicians from different parties have been killed. We still need PKKTT. In particular, we endorse the vetting reform, as I said, and establishing a Gauteng counterpart as compared to people saying it's in KwaZulu-Natal. And here in the Western Cape, where the killing of people is like, it's normal. It cannot be normal. When kids and children are being raped, it's not that we are saying all the money must go to PKTT. I mean, yesterday we afford to have 600 million. From nowhere. Chair, I think we still have to transverse that in our portfolio committee. Because it means when we need money, the National Treasury will give us money. We agree that we have to reform the crime intelligence. And its role must be clarified. And I think the Honorable Ngola said that as well. And oversight of the Secret Service account need to be attended, because it was a cause for concern here that that crime intelligence is infested with some dodgy characters who are in fact leaking information. We also note that the leaders call for the expanding of IDEC mandate and properly operationalize the inspector judge. We differ. In fact, IDEC should be should be history. Because it's used to, I think the Honorable Ngola said that as well, that is seen as weaponized against opponents, like the then so-called Scorpion. That if I don't like you, I said it here in this committee, that there's an Indian cabal at IDEC. Sulen or Pepelonchi and Brian Padiachi and Perumal and others. We cannot allow that. That there's a group of people, when the police, we are not saying people should not be arrested or should not be investigated, but it looks like there's a particular agenda there's a particular agenda against some of the top officials in the South African Police Service. Not that all of them are corrupt, because we cannot paint everyone with one brush. You've got still good men and women in blue. The draft should include or preserve the recommendations which largely anchor on our previous submission as Busisiwe party on the anti-corruption oversight. If any specific recommendation from the draft contradicts the evidence, for example, a weak or non-binding probe of the crime intelligence directorate cases, it should be strengthened. Finally, the MKP particular supports the including the recommendation from 47 that all incoming national commissioners must present policing reform plans to Parliament at the outset of their term, as long as the term accountability measures. It must be measured. I'm concerned as well, Honorable Sangoni, because we still have another day, Chief Whip, but you can drink some coffee there. If the draft report formats allow for the minority or additional views, the MKP may append further comments. For example, it may emphasize the need for the committee to consider the classified IG report on crime intelligence, mentioned in evidence but not delivered. The Prima letter, if you remember that, it causes a lot of problems here. You know, I know that he is still in prison, but you know, he was able to call and send emails and yeah. But as the representative of the people, we have to make sure that we indeed make sure that the committee, the administrative and the legal team note this. Any written affidavits filed at the end, all noted by Arenze, the draft should acknowledge this new evidence, items and their procedural status. In particular, the unanswered letter from Germany Prim, handed in the last hearing, should be listed as an exhibit received but not fully verified. It should be listed, but it should be noted that it was not fully verified. Finally, the MK submits that the report be paginated and indexed as per parliamentary practice. Sections should have a clear headings matching their content. All quotes or factual statements drawn from the evidence should be footnoted. They should be footnoted, as done here. And the text should be fully justified and space 1.5 lines throughout the final document. Where the direct quotes from the witness or the evidence leaders are used, they should appear in verbatim with citations. Where paraphrasing is used, it should still reference to the source lines as done above. The MK party offers the submission in the spirit of thorough oversight. We trust that the incorporated these corrections and clarifications will ensure that the draft preliminary report faithfully reflects the parliamentary record. In summary, I want to emphasize the report must note the president's written answers and that he gave no oral testimony. It should record that Major General Khan never testified. Allegations involving Katiso Molif and Morgan Mawela should clearly be marked as unexplored. The inquiry findings on the December 12, 2024 directive, no prior consultation, inconsistent explanation should be fully reported. Documentary evidence gaps, missing attachments should be transparently noted. Any instance where the testimony was contradicting by record, e.g. Minister Mkhunu misstatement must be stated. We stand ready to supply any additional information or clarifications to the committee. This submission, together with the party early inputs and fully evidential record, should guide final refinement of this report. Reference parliamentary transcript are cited above the committee official numbering, Hansard PMG reference, to substantiate all my factual assertions. Chair, I think I've made my submission. I'm going to make a comment before you go to my last comment, because you said it's once and I won't be allowed to come back. Now, Let me marinate my statement. The three comments of the draft preliminary report, Chief Whip and the Chair. The report delivers a measured but damning indictment of the systematic governance failure. It correctly identifies recurring weaknesses in the executive operational boundaries, particularly of this 31st December 2024 disbandment of PKTT. Now, we know now that there is a crime intelligence moratorium, target control, procurement of safeguard, inter-agency coordination, and crime intelligence stability. These are the frame and institutionalized vulnerabilities that enable operational disruption of the institutionalized constitution and origin of public trust. Findings that align with long-standing opposition concern about political interference and the capture of the specialized unit by improper influence. Is deliberately parliamentary limits are both strengthened and co-constrained. The committee rightly confines itself, to the oversight findings rather than criminal determination, understanding that we are not a court of law. We don't have the powers to prosecute anyone. But it would be misleading to say this ad hoc committee has no powers, because when we finish with our report, the Parliament will take the decision on what we have recommended here, our findings and recommendations. This Chair as well. I think it's a concern for everyone. However, this cumulative record, including the contested relationship, high value contract irregularities, e.g. your Medicare. For me, Medicare is a drop in an ocean. The serious matters with South African Police Service. The budget of 127 billion rand, we are only talking about 360 million here. I think we have to dig deep. The metropolitan issues are, for me, untested waters. I'm finishing, Chief Whip. However, I'm concluding. However, Chair, the effective crippling of political killing investigation discloses matters that now require agent. Hence, I was mentioning 7 already been killed. And we are still 3 months to go or 4 months to go before the local government election. And I think General Mkhwanazi was very clear about that here. To say that we need to strengthen, the police service. For me in particular, the PKTT. Now, the report's restraint should not become a shield for inaction. Recommendations are necessary but insufficient without enforcement. Proposal on a clear command boundary, strengthen the IT and the whistleblower protection, crime intelligence governance reform, procurement control, and structured parliamentary monitoring of implementation are welcome. Yet without binding timelines, dedicated oversight mechanism, and political will to confront organized crime infiltration and elite protection network, this risks joining previous commission reports as another well-drafted but unimplemented document. As Mkhwanazi Party, the committee have helped to surface these issues. The real test is whether Parliament will now compel meaningful reform rather than allow further delay. There must be a finding as well to everyone, and we have to make recommendations, because we deal with many people. People are asking us, because as I was saying earlier, that we are representing the people, that some people are arrested, some people are untouchable. They are not arrested. You'll be told about investigation which goes on forever and ever. And hence people have doubts, to say maybe as well us will have a problem, of implementing our findings and our recommendation. I said, no, that will happen. And I hope that we are not going to extend that, because we've been extending until, Chair, what I said earlier in closing, and finally, that maybe by April, I think the Speaker, if he can give us another time, Chief Whip, through your intelligence, that my emphasis on the issue of the judiciary and correctional service, I'm not going to back down on that, because really we promised, and General Mkhwanazi on the 6th, he gave us an opportunity to make sure that we know what we know today. We know today that General Sinono has resigned. We know that today Brigadier Machine has been dismissed. And that tells you that if General Mkhwanazi was not brave enough, though he's got so many attacks, he has so many attacks from left, right, and center. People are not happy. Some criminals are not happy. They tried. Hence, I was saying the one rapist yesterday tried at the Madlanga Commission, but they chow him alive. To discredit General Mkhwanazi's assertion, to say there's a problem in this country in terms of criminal justice system. And it's been proven, even if we have no finding as yet. But the results are there for anyone to see. But obviously, some are driving some agendas to discredit General Mkhwanazi. We are not saying he's perfect, but indeed, for me, where I'm sitting, I'm saying what a blessing to have a man in blue when he was criticized about wearing a uniform, a camouflage. The pettiness of some of the high-ranking officials and some politicians about why we're wearing a camouflage. We're concerned about the uniform instead of the content which he gave this country to reset and to reset the integrity of the police service in this country. I thank you, Chair.
We thank you so much. Go away. You can't. If you go, I go with you. Thank you so much, Honorable Skwasan. There is one statement you made that the President has declined to come before the committee. He didn't. It was our decision, Chief Whip. It was our decision. I have always been sober in every meeting that we had. It was our decision that he was going to respond to questions in writing. We met here and debated it and agreed. Yes. Yeah. And then we sent him questions, all of us who had questions submitted. And the office of the President came back and requested a further extension, and we agreed. Yeah. Oh, okay. The dissenting opinion was expressed outside the meeting. But at the time the meeting closed, there was a unanimous agreement. Honorable members, I see Honorable Chopper has made his submissions. Honorable Ngola has made his submissions. Honorable Sokanyile, Honorable Mattheys, Honorable Skosana have all made their submissions. Can I check? Do we still have any honorable member who want to make cross-cutting submissions before we revert to the theme-by-theme approach? Okay. You want to make cross-cutting submissions, Honorable Sangoni? Do you want to make cross-cutting submissions?
You know, they're not necessarily cross-cutting, Chair, but I will make them cross-cutting so that we can finish. Would that be in order?
Yeah. The reason why I want to ascertain before you speak is so that you are not seen to be enjoying more rights than others.
I haven't spoken. Okay, I'll come to the. Okay, I'll make them cross-cutting,
Okay.
Chair. Thank you so much.
And then, okay, let me determine the order of speakers. Honorable Mngongo, are you ready after her, or you will need some time?
No, good afternoon, Honorable Chairperson and Honorable colleagues. I would need some time to get myself ready, Honorable
Okay.
Chairperson. Thank you.
Honorable Breitenbach, are you coming to speak?
Chair, I'm so tired of listening to everybody else speak. I was largely covered by Honorable Klopper. If I need something, I'll wrap up at the end, but not.
Okay. Honorable Cameron? Now, let me give you time to finish what you are doing, and then you will let me know. Okay. Chief Whip?
No, Chair, it's the same for me as with
You
the
are
Honorable Breitenbach.
Okay. So it means Honorable Mwango, we will check with Honorable Sols when he comes back. And then it means it will be him, and then you will be the last. And in case he's not here, we are going to close. Okay, Honorable Sangoni, this is your time now.
Thank you. Thank you very much, Honorable Chairperson. I think I'll be very brief. I promise you nothing like Honorable Skosan. Chair, let me thank you, for having steered this process until where we are now, and to also just echo appreciation to the team for the work that they've put in. This report, I think, as it currently stands, is a testament to the work that we had sought to do. As the African National Congress, we don't believe it's perfect, but we think that in a large part, it fulfills the mandate that we had to ensure that where governance failures are identified, where there are allegations that have been put forward and so forth, those are thoroughly investigated. And I think taken together with the Madlanga Commission, we don't necessarily believe that, it's a weakness that there were parallel processes, but that it has strengthened what we believe Parliament and the President would have sought to do, which is to really open an avenue for South Africans to engage on the challenges that are there within the criminal justice system, but beyond that, to look at what solutions from a reform perspective can come through, but also in terms of the prosecutions that we are seeing. So we commend these processes, and I think we must be clear that it shows the determination of this government to fight against corruption. It shows the reforms that have been put in since 2018 are starting to bear fruit, and we believe that going forward, the implementation of these reforms will take that fight much further, Chair. Chair, as the African National Congress, we took an approach in this process, and I think it was what we understood as the mandate of our party to approach these proceedings with an opening and inquiring mind. And what that meant was that in the hearings, we were open to all possibilities. We were looking to see whether the truth had been told. We did not come here, unduly suspicious, unduly believing. And I do want to put it on record, Chair, that I think from the recommendations, referrals and findings that our colleagues in the ANC have made, you will see that we have lived up to exactly that commitment and posture. So what I'm going to do is to just speak on the last few set of recommendations, and I think these speak to the issues of public trust, of institutional credibility, of national security implications. But I wanted to start with just an addition on the limitations. We think, Chair, we've never seen you angry in this committee until the day you had to interact and inform us on issues relating to how the committee through yourself was being treated by the JSCI. And we think that that was a major limitation on the work of this committee, as we never got to ultimately engage then with what the now suspended IGI had wanted to put on before the committee. So we think that that must be raised. I know there are honorable members who think that we shouldn't consider some of this as evidence, but again, from the ANC, we approached it from a perspective of looking at a balance of probabilities. So all the versions that had been put to us, which is most likely true, and the questioning and engagement we did was part and parcel of that. So on the first one, Chair, that I want to speak to in terms of recommendations, it's a recommendation which relates to the civilian secretariat of the South African Police Service. And I want to preface it by saying section, if I'm not wrong, section 204 and section 208 of the Constitution of the Republic of South Africa are identical, actually word for word, when it relates to the establishment of a secretary for police and a secretary for defense. If you give me a second, Chair, I'm just trying to go to that section quickly, if I can find it here. Okay, so the section in the Constitution speaks to the establishment. Okay, I can't find the exact section. It speaks to the establishment of a secretary for police and a secretary for defense. Exact same wording in the Constitution. Now, what the Defense Force has done is that, in accordance to what they understand to be civil military obedience, the Defense Force went to establish a Secretary for Defense who is the accounting officer of the SANDF. On the other hand, the SAPS went to establish a civilian secretariat service which plays some sort of oversight role, or not some sort of oversight role, policy, stakeholder engagement, and so forth for the police. We want to contend that the challenges that you are having within the South African Police Service, some of them are occasioned by the fact that you expect uniformed officials who are trained police service and men to be running an administration of government. And we are making a recommendation that we should consider an amendment that the SAPS Act must be reviewed and on the powers and functions of the Civilian Secretariat for Police, as I indicated, within the context of the civil military obedience as modeled in the Defense Force. The differences in powers between the Secretary of Defense and the Secretariat of Police is important in that the two institutions are born out of sections of the Constitution that are similar word for word, and the Defense Act assigns the powers of accounting authority to the Secretary of Defense, and the SAPS Act assigns the powers of the accounting authority to the National Police Commissioner, as opposed to the Secretariat of Police. So we're recommending that amendments should be made to legislation to ensure that the Secretary of Police is the accounting authority and the National Commissioner be the head of operations, similar to the Chief of the Defense Force in the South African National Defense Force. On the second issue, Chair, relates to the Section 6 of the IPED Amendment Act, which allows the Minister of Police to nominate a suitable candidate who must serve as an executive director with the concurrence of Parliament. The Minister is then ultimately responsible for the dismissal or any career incidents of the executive director, as well as the renewal or non-renewal of their contract. Now, our proposal is that this section of the IPID Amendment Act should be amended to allow Parliament to process applications for the executive director and to interview suitable candidates, which can then be recommended to the president for appointment. We are further saying Section 31 of the IPID Act should also be amended such that the disciplining and recommendations for the removal of the executive director to be the responsibility of the Secretary of Police with concurrence with the Portfolio Committee of Police. And as I said, this may necessitate that particular amendment. Chair, you'll remember here we had received testimony from Mr. McBride, who alleged that there was interference specifically by former Minister Nathi Nhleko in relation to his work until he was ultimately suspended. Now, we believe that too much power currently resides with the minister when it comes to the appointment and career incidences of the IPID director. We are also proposing, Chair, that the draft committee document makes a lot of recommendations with regards to mandate overlaps, rule clarification. So we're not going to repeat that, but we do want to add that we need to ensure that the civilian secretariat and IPID, their mandates are also clearly delineated between the two. Civilian Secretariat is a constitutional body exercising civilian oversight over the police service. IPID shares more or less the same mandate, and consideration must be given that IPID is located under the Civilian Secretariat body of the police instead of the Minister of Police, once again strengthening that delineation and independence that we are looking for there. Also on IPID, Chair, we've seen IPID get weaponized a couple of times. A number of recommendations have been made in that regard. We just want to add one additional recommendation, which is that Section 28(1)(c) of the IPID Act is also considered for amendment. This section currently reads that the Directorate must investigate any complaint relating to the discharge of an official firearm by any police officer. Now, this has been, as I've said, weaponized and abused to investigate police who are executing their lawful enforcement powers. And we'd wish that we strengthen it, that we confine the investigation to the unlawful discharge of firearms by members of SAPS. And then finally, Chair, you had said that there was a matter that we had raised in the morning that we could return to, and you will advise me when perhaps we may return to it, which is the treatment of issues that have since come out at the Madlanga Commission. Specifically, in this instance, it was relating to the evidence that Mr. Matlala had tabled before us regarding what he said was extortionist practices from Mr. L. Now, we do believe, obviously, that he who alleges must prove, but given the fact that now Mr. Matlala's plea bargain, we don't have sight of, we don't know what to make of his evidence, so we're not able to make a recommendation there, but we would still wish to do so when an opportunity arises. Thank you very much, Honorable Chairperson. Those are our submissions. Leanne, the African National Congress rests. Thank you.
Thank you so much, Honorable Sangone. Can you speak through the microphone?
Leanne, the chairperson, please says repeat that you are impressed with the African National Congress on the record, please.
Through
Thank
the
you.
microphone.
I am so impressed that after the months we have spent here as the EFF with the ANC, that we were managed to successfully incubate the ANC into superior.
Okay. Yeah. you have used the word impressed in the same line with the African National Congress. Thank you so much, Honorable Sangoni. The last part that you have mentioned, we may not be able to discuss it today because there may even be more information coming from the plea bargain than only the part on extortion. So I think those three matters, one, matters that will be emanating from the plea bargain of Mr. Matlala. Number two, the information that was presented at the Madlanga Commission yesterday by Honorable Shongwe. And three, the claim that there were witnesses that were ought to be protected by the ad hoc committee and they were not, which was made by Honorable Breitenbach, and any other matter that may be brought to the attention of the committee. Let's wait until all those details have been sufficiently provided. And then we can decide when, before we do the final adoption of our report, come and discuss these matters. Honorable Sols, yourself and yourselves, Honorable Sols and Honorable Mwango, are the two members standing between us and the adjournment of the meeting. So Honorable Mwango has requested that we take you before him so that the input and the comments that you make can also help him to settle. Because I told him that in the morning when we started, the majority of the honorable members looked very tense and nervous, like they were going to the examination room. And that happens to be infectious on his part. So he also wants to settle. And he requested that we must humbly plead with you to present before him.
Chair, I have never made it a habit to say no to you.
Yeah.
And
I know that earlier on you requested to take your presentation theme by theme. You can still do that, but this time you are going to do it without being paused. If you want to start with theme 3, you will alert us to say, I'm starting with theme 3, and then you present and say, Chair, I'm now done with theme 3, I'm going to theme 4. Or if you want to just start it and finish it as a cross-cutting presentation, you are also allowed. The ball is in your court.
Chairperson, I note your implicit instruction and I'll even submit to that one.
Okay.
And just for clarity, it is at this point that at the end I can provide my input on the issue of the recommendation.
You may no longer have any other opportunity, so use the opportunity that you have maximally.
Thank you, Chairperson. All right, so I think I'll start at theme 4.
Just a moment, Honorable Matthews, you were not here when Honorable Skosana was making a presentation. Yeah, there is part of his presentation that you missed. Yeah. Okay. Yeah, so now let's allow Honorable Sols to make his presentation from theme 3 up to theme 7, including findings and recommendations, which is page 432. So he will start from page 278. I mean, page 298 to 432. Thank you so much, Honorable Sols.
Thank you, Chair. I want to just reiterate, firstly, that our approach to ensure that as a committee, we do not come across as having chosen a side. My commitment is to ensure that we treat all the evidence fairly and we make such submissions. So I want to debunk the notion immediately that there is no one here that wants to discredit our hero with holes, General Mkhwanazi. No one wants to do that here. Our job is to submit our findings and having heard all sides. So that is my commitment. And the report here seems to be creating an imbalance, and I am going to attempt in my time to try and bring that balance so that we have both sides properly reflected. Theme number 3. So the structural fragmentation and communication failures between the provincial commands, specialized units, and the national oversight bodies. I propose the following findings. That we state that we found a severe breakdown in lateral communication that exists between the KwaZulu-Natal Provincial Command and the National Crime Intelligence. This lack of integration resulted in specialized operations being handled within institutional silos, directly degrading operational efficiency and fostering mutual suspicion. We further find that the parallel reporting lines used by various commanders bypassed the established statutory chain of command, creating an administrative environment where critical intelligence was weaponized rather than shared through formal channels. Our recommendations on that front: we recommend that the National Commissioner must issue a binding directive mandating the creation of a joint operational coordination protocol. This protocol must legally bar any provincial or specialized commander from executing or altering high-stakes unit mandates without formal, written cross-authorization from both national and provincial structures. Theme 4, the integrity of the systems and evidence validation and accountable witness standards. Here, of course, our focus zooms into the vetting framework, the forensic data reliability, and holding all leadership, including General Mkhwanazi, to uniform standards of truthfulness. Everyone must be treated equally. The committee, I propose, should find that the integrity systems within SAPS command structures failed significantly when senior leadership acted upon and publicized unverified, flawed forensic data. We have already mentioned the other witnesses that has done so, but this report has intentionally neglected that the same happened with our hero, General Mkhwanazi, with the formal retraction of his explosive allegation that Mr. Matlala made illicit payments to former Minister Becky Cele. That in itself, stated under oath, reveals a profound failure in basic investigative verification. And just like we do with other witnesses, that basic investigative verification failure should be mentioned as something that compromises the operations of the South African Police Service. And of course, the only reason why I'm not mentioning the other witnesses is because they are already mentioned, and there's already a zooming into the failures on their side. I'm just trying to create the balance. Further find that relying on misidentification of cell phone numbers to level career-ending corruption charges against executive figures demonstrates an unacceptable evidentiary gap within SAPS. Acted upon prematurely, these unverified claims caused severe reputational damage and actively destabilized the institutional governance and operations of SAPS. Further finding, to achieve complete balance, the committee should look at the proposition of a finding that the report must cross-examine the nature of General Mkhwanazi's own record, hotel meetings with Mr. Ket Matlala, or meeting, we only know of one meeting, just as the report rigorously tests the integrity of, for example, former Minister Becky Cele's presence at the properties linked to Mr. Matlala that caused, unfortunately, the death, or it's linked to the death of, allegedly, Babita Deokora. In the same way that links are tested, so also it must apply an identical standard of scrutiny to the presence of General Mkhwanazi at the hotel meeting with Ket Matlala, to determine whether his provincial command was compromised by a conflict of interest or an allegedly corrupt relationship. So here's the recommendations. It is recommended that the Minister of Police initiate an independent administrative review into the conduct of Minister Mkhunu, all the other generals, including General Mkhwanazi, regarding the premature dissemination of, in his case, false cell phone analysis data. This review must hold him to the exact same disciplinary and credibility benchmarks applied to all other witnesses. Recommendation, the Inspector General for Intelligence must investigate the hotel meetings to establish a definitive, publicly transparent finding on whether any conflict of interest occurred, ensuring that rank does not shield any official from accountability. Theme 5, resuming to the focus of allegations of corrupted supply chain management and the operational impact of executive proximity to state contractors. We find that proximity between high-ranking police officials and active state vendors, such as Mr. Matlala, creates severe institutional risks and undermines procurement integrity. A recommendation there, National Treasury, we recommend that National Treasury must assume a supervisory role over all high-value SAPS security, if they are not already doing so. SAPS security, technology, and specialized unit procurement processes to prevent any perception of executive or provincial command manipulation. Theme 6, resuming the continuity of specialized investigative units amid administrative restructuring and leadership conflicts. We must find that the operational effectiveness of specialized units, including border protection and political killing investigations, was severely compromised by the internal civil war within SAPS top-ranking leadership that in our sessions was dubbed informally as the Zulu War. The unilateral withdrawal and relocation of 121 active case dockets from KwaZulu-Natal to Pretoria, driven by internal distrust and allegations that were later retracted, stalled critical prosecutions, and degraded provincial policing operations. Recommendations: the National Commissioner must enforce a mandatory docket security protocol. No active investigative files may be removed from their local jurisdictions based on unverified analytical data or personal leadership disputes. Theme 7. Here, of course, we focus on restoring public confidence by ensuring the uniform application of accountability rules across all ranks. The committee finds that public trust in SAPS has been deeply eroded by the spectacle of senior commanders using unverified intelligence to launch mutual accusations of corruption and insubordination against each other. And when we were sitting here, none of them, no general, was willing to state for the record either one of the other that they alleged against is corrupt. That was frustrating to me, because if you make the allegation, all of them must come and say, I say this one is corrupt because this, that, and the other. But none of them did so. So that affected the public trust. As a recommendation, this final report, Chair, must append a formal witness credibility rectification matrix. This section must explicitly document everyone's testimony regarding financial corruption that was flawed fundamentally, and the fact that certain testimony was retracted. His own and that of others, the interactions with figures of interest require identical forensic scrutiny to ensure the rule of law is applied equally across SAPS. And then, Chair, I'm going to go to my input on the recommendations made by Honorable Mwala. Was it Mwalo? My very intellectual colleague. I seek to disagree with him on those recommendations that he made, that Honorable Adams, that we must recommend that Honorable Adams and Patricia Mashale, Honorable Adams must be sent to ethics and Patricia Mashale must be investigated. I feel that this is a blatant attempt to penalize an official for refusing to complicitly participate in a compromised system. Narrative that Honorable Adams acted in bad faith by not surrendering the documents that he had of the case where he opened up the cases. Is incorrect. And the reason why is because Honorable Adams explicitly testified that he withheld specific files and bypassed certain channels because he possessed a well-founded rational fear that the cases would be actively suppressed, destroyed, or buried by compromised elements within the SAPS. And as we know, in the hearings, it came out that his fears was real. And that's exactly what happened to those cases. I agree that the other entities which are investigating him, they should continue. Those independent entities should continue. Whatever cases, criminal cases is made, opened up against him, that should continue. He must account. But here, us in Parliament, to send an honorable member to ethics because he came out and explained why he did what he did, and then others testified, generals testified that what he feared actually came to pass. His case dockets was locked up in a safe in an office and not investigated. So it is absurd, an absurd inversion of justice to demand an ethics investigation into the man who tried to prevent evidence from being hidden whilst remaining silent on the systematic corruption of police officials who literally locked criminal dockets in a safe to protect suspects. Honorable Adams acted to preserve the integrity of the evidence, and his actions should be commended, not criminalized by this committee. However, the jury is still out on the criminal element of that by other entities who are investigating him, who has charged him, and we will wait until the guilty verdict by those entities. Similarly to Ms. Patricia Mashale. Ms. Mashale's credibility must not be ignored, but it must be questioned, sure. But she came as a whistleblower, and she showed us years upon years, how she sought to expose corruption within the system. And Section 1513(2) of the very report draft speaks of the fact that whistleblowers such as her should be protected. So as such, it is our position that people, not only Ms. Patricia Mashale, but also other whistleblowers that came here, sat before us, risked their lives in many instances, and gave us information under oath that assisted us to get to this point. We should not create a precedence where we put more pressure on them and make them fear next time to come forward and bring experiences and proof of possible corruption in our institutions. With that, Chairperson, I rest. I'll say thank you very much.
Thank you so much, Honorable Member, for using your time optimally. The last submission is coming from none other than our own Bangazeta, the Honorable Nwango himself.
Well, thank you, Honorable Chairperson. Quite honestly, I'm not going to take much of your time because there isn't really very many, variances that one has with the already made recommendations and observations. Safe to say that I do want also to put on record our appreciation and admiration for the manner in which you have acquitted yourself as chairperson of this process ever since we started. And I really must applaud the manner in which you have actually handled matters. Sometimes things would get heated up, but you maintained your cool. Thank you very much for that. Yes, well, I think my view and our observation is that with regard to the definition of roles between the executive authority and the accounting authority, in this instance, the National Commissioner, I would suggest that we actually zoom into that and actually attempt to get a clearer definition so that there shouldn't be any ambiguity in the roles of these two authorities. I'm saying this because at the center of this process was whether or not the minister acted within his executive rights to actually disband the PKTT. And on the other hand, the National Commissioner believes that that was his prerogative in terms of the Constitution and in terms of his mandate to do that. So we would need a clearer definition of the roles in that regard so that in future we prevent, these misunderstandings. I do want also to look at the current ranking regime that is there within SAPS. I would be very, content with a ranking system that would be transparent and also be based on merit and not necessarily on any other consideration. Because my fear is that you are going to end up with a top-heavy kind of a structure with a lot of generals who have actually very little operational experience, because clearly some of the generals that we met here are people who actually were recruited from the private sector, and they were parachuted, whether I'm not sure that that word is correct. They were promoted into or translated into brigadiers and generals, and when they have not actually even seen a docket, and then they end up being divisional commissioners, that's a serious, responsibility. So I would imagine that it would be necessary at some point to review our ranking or grading system. The vetting, the internal vetting also was a sore spot in our discussion here. And you have very many leaders of the police service who actually have not been vetted. And that has, resulted in disastrous consequences. And the police service has found itself being led by people who should not have actually been there in the first instance, had vetting been properly done. So I would imagine that we would make a strong case around the issue of vetting. In fact, not even vetting only, but also lifestyle audit. You would not understand, like myself as a lay person, why would a major general actually, operate 5 Ferraris or own 5 Ferraris? I'm not, I may not be au fait with the salary structures of various categories of ranks in SAPS, but it raises eyebrows when a senior police officer becomes opulent and so rich. So we would need to get into that as well. The crime intelligence division is a source of great problems in the operations of the police, and allegedly because of the existence of the secret fund, which is actually located within crime intelligence. One would actually plead for the introduction of some mechanisms in the management of and utilization of the fund that would actually ensure accountability and effective utilization of that fund. I'm not sure whether one can even add transparency, but now it defeats the purpose because it is secret fund, therefore there can be no transparency. But there has to be some mechanism.
There can be an accountability mechanism.
Thank you, Chairperson. I think if we were to reinforce that, I'm sure we would see lesser and lesser problems emanating from that division. My last point has to do with the role of IDEC. I think that needs to be reviewed because already there are quite a number of entities within SAPS that are focusing on issues of corruption and so on. So one wonders, why do we actually need an entity called IDEC, especially its current role is, because from where I'm seated, I can see that IDEC is being manipulated for some dubious, motives, which have nothing to do with the investigation of corrupt activities and so on. it's now being used, to get at each other. So I would actually, Chairperson, submit that. That's all my submission. Thank you.
Thank you so much, Bangazita. Can I check if there is anyone amongst you that I could have missed, or who may have a point that they may have a sense of gross injustice if they leave this meeting without having raised it? You are now on the referee's optional time. I'm exercising this benevolence because it's the time of the World Cup. After 90 minutes, you have some 6 or 7 minutes, which is the referee's optional time. We will start with Honorable Breitenbach.
I thought we had a deal. You've got no idea how to do a contract. I must teach you.
I'm checking with you if you have anything you want to say. Let me note how many.
I said what I want to say.
Yeah, 3, 2 minutes each. Honorable Ngola.
I just need a few seconds, Chair. I just wanted to say, Honorable must leave the issues of Ferraris to us. He must focus on Toyota Stallions and Potatoes and stuff. Thank you.
Okay. Honorable Skosana. You heard it, Magazit, that those ones are not for the veterans.
The only thing Ngola doesn't know that Mr. Mngwango is a Range Rover. It's not on those things. He's talking Italians. Thank you, Chair. I just want to wish to deposit this to you that it's been a long journey. And I hope that the issue of the witnesses, that if I remember well, that they'll be given a chance for the next 10 days because the deadline is on the 31st, if I remember well. Now, all what we deposited here hopefully is been captured by the admin team. And obviously we won't agree to everything. Hence I said when we started earlier that you'll have minority opinion and majority opinion here. We'll always dissent. Some they've got their own opinion like everyone else. But I want to emphasize once again, Chair, in the last 2 minutes, I've got 1 to go, that it is indeed critical for us all here that we behave in a manner that is not embarrassing this parliament. We are all equal before the law. Honorable Skosana is equal to any other member here. There's no one who's above the law. The insinuations about other members, it's normal that, you'll always have to that. But indeed, the issue of Honorable Ngola, which he emphasized earlier, will be tested. But I don't want to go back there because we've got offices, all of us there, and we requested that the parliamentary security personnel gets the evidence when it comes to the issue of an envelope, be put under the door. We need that on that particular dates. We need that camera. If that's the case, then we know that we have protected the integrity of this parliament. It's not a gossip because now we can always speculate and say one is lying, this one is that. But we have cameras in this parliament. I thank you, Chair.
Thank you so much, Honorable Matthias.
Thank you, Chair. I skipped this because it was written in my hand notes. is that the report says that we had access to classified information. And while the terms of reference had outlined how we would access classified information, it didn't end up happening. So that must be fixed because it's in multiple paragraphs that we accessed classified information. And what we also missed is that issue of us having those scanning machines at our borders. So this is me responding to some of the issues that has raised. So I think we must be able to find expression where we give directive to the relevant department that, what are they called? The border posts, those scanning machines, because Lieutenant General Mkhwanazi says there's only one in the whole country. It can't be. And we have the issue of, so that's one of the, one of the recommendations that we must be able to make in that regard. And then just finally, and this is to go on about the matter of the information regulator and civilians accessing our credit history, etc., Paul O'Sullivan. That company that he says he's a member of, which is what is certified board of what. That company must be mentioned, and we must refer it. The information regulator falls under the Department of Justice. They must come and answer how they access this information. How do they give membership? Because from what I understand, you just pay for a membership fee, and then you have access to this information. And our information regulator means that we have to sign, you have to give permission. So that company must come and answer outside of us investigating how Trent and Sullivan has it. But he mentions this company multiple times that has qualified him as a forensic investigator and gives him access to that information. So I think that must be noted as well. And that's I rest. Thank you, Chair.
Thank you so much. Honorable members, let me thank you so much for your objective analysis, for your robustness and incisiveness. If you remember, all the witnesses that appeared before us, there is one important word that we mentioned when they were taking oath, that the evidence that they will be presenting before the committee will help it in its oversight responsibility. And I have heard many of you emphasizing it here that the work that we are about to conclude in the report that we are going to produce must uphold the integrity of Parliament and reaffirm its oversight function. But very importantly, honorable members, we must demonstrate our vigorous intention, or we must vigorously demonstrate our intention to reinstill public confidence in the ability of Parliament to play its oversight responsibilities. From where I'm standing, to a large extent, honorable members have agreed with the assessment or the broad thrust of the assessment that has been made by our evidence leaders and the content team. Of course, there are important additions that have been made where some aspects would have been lacking or inadequate. There is only one honorable member, that is Honorable Skosana, who has said that he supports the findings and the recommendations that have been made by the evidence leaders. And the point that we may need to check is whether there is convergence, a wholesale convergence between the recommendations of the evidence leaders and those of the content team. So that when the draft, the final draft, which is going to be considered for adoption, is made, you are able to reconcile those recommendations. So what we will do, we will allow the content team to go and incorporate the inputs that have been made by members here today and highlight those where there is general agreement and where there is a dissonance in terms of submissions would be put in another category, so that for the purpose of this adoption, we don't sit in a long meeting going through everything where in some areas there are agreements. We did not meet here today because we wanted to adopt the report. We met here to finalize the report. And if you remember, I said the reason why we must finalize it is because we must send it out to those witnesses that have appeared before us. They can make their own inputs and comments like we made here. And then we will come back and consider all those inputs and comments in the process of adoption. And I want to check with yourselves before we leave here. Is there anything materially significant in the assessment that we have made, not the recommendations? Is there anything materially significant in the assessment and findings which may make it difficult for us to share the report with the witnesses? Or if we may not be ready to respond to the question, I can say to you that let's allow the content team to go and finalize the submissions that you have made here. And then we can call a virtual meeting to check only the findings and the assessment, analysis and assessment of evidence. Because the report that we send out to the witnesses, our recommendations are not necessary. What is important is our assessment and the findings that we make. The recommendations is for the committee to recommend in whatever way, and we can never in any way be influenced by anybody how we must recommend. But the comments and inputs that they will be making on the assessment and our findings can also help us to arrive at certain recommendations. So maybe instead of me bombarding you now to commit yourself to say there is nothing materially significant, can we allow the content team to go and incorporate these submissions that you have made? And then we can agree whether we meet very soon, maybe next week, Monday or Tuesday, to check if our assessment and if in our assessment and findings there is nothing material that can stop us from circulating the report. Is there any dissenting view? Chief Whip?
No, Chair, I'm not dissenting. I'm just making an additional point to what you're saying. I want to propose that when the report comes back to us, it should also indicate where, in the opinion of the team, there's alignment across all political parties.
Yeah,
And also be very clear where they are of the opinion that we disagree. So that when we have a meeting, we see how to iron out our differences rather than, discussing the whole report. Of course, we
Yeah.
still have to see it, but I think what to be more urgent, in my view, would be to deal with areas of divergence. Thanks.
yeah. Okay. Can I check with yourselves, the outstanding team? How long will it take you?
We'll try and have it available for you by Monday. Is that okay?
Yeah. So the final draft will be available on Monday. And then, Bonani, when are you thinking of calling the meeting? Yeah, the final draft will be available by Monday, so we can meet on Wednesday next week. So that members can have time to go through the final draft, and if there are certain matters that you want to raise with the content team, you can do so. Agreed? Do members want the meeting to be physical or virtual? What are you doing? Can you motivate why you want? Let me rotate the motivation.
We're busy with communities, Chair. We candidate elections.
No, I wanted to rotate the decision. No, honorable members, thank you so much. Yes. Is there anything you wanted to say, Honorable Matthys, before I thank the members and adjourn the meeting?
Yeah, you have to sit when I'm talking. You don't know these things. You can even kneel if you like, Honorable, because I'm talking. Chair, we're not opposed to virtual meetings because, we are all busy. But we must also just be honest with ourselves that we're much more effective when we have physical meetings. But I think we must all just, when we schedule the meeting, that we have good reception, that we are not doing other things so we can move smoothly, because generally our virtual meetings just, you know how that goes. So let's just make sure that it is so it can just go smoothly. Thank you.
Do you also want the adoption to be virtual or physical? Virtual, 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 physical, virtual. Okay. There is only one member saying physical, so. Honorable members, we have come to the end of today's meeting. Thank you so much for being businesslike. This meeting was built for 2 days. You did it on 1 day. You are the best team to work with. Thank you so much.